When are we going to break for lunch, Judge?
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
I was getting commentary on his case. Dati mihi Anglican por his verbis Latino.
That's literally not true.
Is that correct?
I didn't ask you to interrupt me. Oh, for crumb's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Hope you had a fantastic lunch. I did. Had leftovers and some non-leftovers. My leftovers were chicken fajita. Just the mix. I just ate it out of the bowl like a heathen. But the chicken fajita fixings without the wrap, without the tortilla, right? So I just had it cold, just the peppers, the chicken, everything out of the Tupperware dish, out of the fridge, and then some mac and cheese just to top it off. so it's all good. All right, we have something very important happening right now. Kimar says, please gift the internet to Kelly H. Boom, done. Kelly H, congratulations, you are the winner today. That means everything I pre-dated worldwide. If there's a problem with it, it's your problem, not ours. Kelly H, congratulations on your win. This counts as if you were first in chat because you can regift the internet one time each live stream, and it's been regifted, so you are stuck with it. Like it or lump it. No, but it's yours. Congratulations. Kelly H, you are our internet winner today. Yeah. Let's see. We are back. We're about to be back in court. They've got a couple things to do, like get everyone together. Right now, the courtroom is pretty much empty, which is cool, but we need a few people. We'll keep an eye on that. And man, the judge has a nice chair, if I say so myself. Reverend Beasy, I had a mile for lunch. You need to ease up on those miles. You're consuming them at a rapid rate. We voted in chat, decided AWOL podcast, and I should run the stream and discuss court like jurors in your lunch break. This is Legally Blonde. That could be pretty wild. I'm just saying, AWOL and Legally Blonde together. It might have to be a late night stream. I'm just you guys are two strong characters there. That would be awesome. I did not vote for that, says AWOL. You got nominated, AWOL. It's like winning an award from your peers. You don't vote for yourself. Other people vote for you. The mods didn't approve that. The mods are like, wait, what? Legally Blonde and AWOL voted for that. Not all of us as Gaily Mayo. So now everyone's complaining. Nobody's happy with the outcome of this election. Whatever happened over lunchtime, we need to revisit that. It was pretty wild from what I saw. They need to work on YouTube-friendly language. I saw a couple comments. Some of them I approved. Some of them had been caught by the YouTube filter as what was going on during lunch. I demand a recount. I'm sure we've got a hanging Chad somewhere, right? Or a dimpled Chad. Nobody asked you, mods. Oh, yeah. Wonderful. It's good to be back. I will tell you, we didn't talk about this much, but we heard about something called a Rule 29 right before lunch. Defense, after the jury had been excused, defense said, Rule 29, Judge. And he said, yeah. Prosecution? And they're like, yeah. And they're like, okay, denied. That was the entire judgment of acquittal. I don't think the defense even got his butt off the chair to make the argument. He just invoked the rule. It is a full judgment of acquittal. For all appellate purposes, it would be equivalent to him standing up and giving a 20-minute oration about the wrongs of the state and what they have not proved and just where the reasonable doubt is. It's the same. It's preserved for the record. He made the motion. Judgment of acquittal is denied. The case goes forward. It's important that the Rule 29 or judgment of acquittal argument, or even the motion, and more importantly, the ruling, doesn't happen in front of the jury, because the jury is not supposed to get any sort of influence whatsoever from the judge as to whether or not there is merit to the state's case. And if the judge hears this argument in front of the jury, or rules in front of the jury and says, nope, there's evidence there, that puts some credence and possibly some extra weight that the jury's like, maybe the judge has seen something I didn't. He's more seasoned. Maybe I should go with his opinion. That's why it always happens outside the presence of the jury. Is it just me, but is RA dipping in and out? I think it's just you. Try to refresh your screen. Refresh your page. It might fix it. We've had a couple issues this morning. Legally Blonde, watch it. I brought you the trial out of Warren County for a late birthday gift. No more Warren County trials for you if you don't behave. Josh. That's awesome. Ivan stole my commissary. 2AO Toys. Well, just go ahead and take a number. Take a number. We have a number of complaints that have come in about stolen commissary over the lunch hour. And all will be investigated fully. We will get to the bottom of this. We're going to do a full inspection of every cell. If something's been stolen, it will turn up. Let's see. Have we done a poll yet? No, we don't do a poll until the very end where they rest, which I think they still need to do in the presence of the jury, right?
Have them send someone with more experience.
I love hearing Mr. Farag's voice, knowing that he's back. Phil, did you see? Farag is back. Our missing inmate from Tumwater, Washington, Thurston County, Washington, has been found after 22 months of being on the lam. He literally walked out of his own trial at lunchtime 22 months ago, and he's just now been found. He will be back in court tomorrow, and it's going to be interesting because he's still the same Mr. Farag. He still has the same two sister German Shepherd dogs that are worth a fortune. He's invested a ton of money into. And that is his life and everything else. And he's still arguing about his car and the odds of it getting stolen. He gave out the address of his car. He's sitting in jail. He's like, right now, my car, which is a hot commodity for thieves, it targets one of the highest stolen cars in the country. It's sitting at this address right now, and I haven't been able to secure it. And if that got stolen, it's got 2 computer devices in it that are necessary for my defense. It's like he's asking somebody to do it, as if that would give him reason for delay. But if you missed it, last night we did cover his appearance, which happened yesterday. He will appear again, possibly for sentencing, and many other things tomorrow. Farag is back, yes. Let's see. He's going to file his list of grievances as well. That's going to be exciting with his stubby pencil. I'll get the stubby pencil soundbite. I will. Trust me, it's on the menu of things to do, above all the other things Amber's asked me to do. It's this car and this license plate, and that's the park and ride lot it's in. He gave us everything. Everything. Booking a flight, I'll feed his shepherds. I hope somebody is. It sounds like he's been in touch with some people on the outside, but nobody's been able to secure his vehicle yet. He needs paper first. I do hope his dogs are okay. Let's see. Maybe Mr. Farag needs a song. Yes, we need the stubby pencil soundbite. All right, people showing back up in court. Looks like court employees finding their way back in after the lunch hour. Just getting seated. We've got about 6 minutes before the judge said everybody has to be here to restart. We will not have a court watcher this afternoon because Roman ADCC has other obligations. And Legally Blonde can't find an inner to drag her butt down to court and watch for us. No, just kidding, Legally Blonde. I know you can't as well. I'm just giving you a hard time. 2 locals, though. Appreciate those that are able to go and watch court for us. That's awesome. We do find out from our court watcher today that we have a jury of 14, obviously 2 alternates. They are 7 men, 7 women, and they're asking a lot of questions, a ton of questions. That was fighting words. Bring it. I'll see you in court. No, just kidding. You probably would win, so please don't sue me. When are we breaking for lunch? All you have to do is type !lunch, and that's the command that plays. I'll even turn the volume up for that one, and just that one. Is the frog thumbnail? We have one from yesterday. Here we go.
When are we going to break for lunch, Judge?
Hush! Now I'm trying to have court. You don't raise your voice again.
Have them send someone with more experience.
Okay, hush squeezed in there. But we got some other ones that were just Mr. Frog. All right. I can't sue you. You're my client to the end. Remember, we beat greeners together. Yes, those were the good days. I remember that fondly. I'll make a frog thumbnail and playlist this weekend with timestamps. That would be awesome, Red Pen. Thank you. Judge TNT is dynamite. This is his initials. That's correct. Held back all my comments about a stubby pencil. Emily, thank you for being so reserved. Stubby Little Greeners is licking your wounds. Let me find, where's my timeline? Stubby Little Pencil timeline.
Saw a chicken fight.
I think it's this one. If somebody knows where in the hearing, like, this happened. I've got to watch. He holds up his hand and he makes a little gesture. Oh, there it is. It might be right here. Let me see if this is it. Just listen. Everyone's coming into court. It's okay. I can play it.
But I've had since they were 8 weeks old.
The German
and my
Shepherds.
car is out at Park and Ride in the Kent Des Moines Road. I can't seem to get that secured and returned to Olympia. And I've already done 5 days jail. I want credit for jail time served, Judge.
Okay.
Going back
Well,
to
see,
day one.
okay, hang on just a second there.
Yeah. Okay, there's a lot. That's from last night. Yes, Mr. Frog is a flight risk. They're not going to let him go until they are done with him. Can you believe he comes into court and he's like, Your Honor, I need you to be lenient with me. Grant me a little bit of mercy here. Cut me some slack, would you? Because I have operated in good faith. I showed up to court and began the proceedings. I'm in good faith. Operating in good faith. I don't think you can count absconding mid-trial as good faith. I think your definition of good faith and mine differs. Park and Ride on Des Moines Road. Yes, that's where the car is. Please don't steal it. 2 years later. I just need more time. Judge handled him beautifully. Eventually, he's like, Sir, you just need to stop talking. Your hearing is over. The decision is made. Let's see. I think we're about ready to go back to court. Looks like... Ooh, who's here now? Somebody that knows the prosecutor. Apparently the prosecutor is not feeling well at all and about to just literally head to the hospital. So, Moore crawling under the desk is the best. I have to admit, I sort of did Ms. Moore dirty there. I prefaced and told you she wants to be anywhere but here, wants to crawl under the desk. She had to crawl under the desk to unplug her laptop. That's why she was under there. It wasn't that she was just like, oh, I quit. I'm just crawling under the desk and I'm just going to hide here until Mr. Frog gets released from prison. That was not it. But I thought it was funny because the timing was perfect. Sorry, Ms. Moore. I like your version better. She did crawl under the desk. Bring the defendant. All right. Can I run to the bathroom? Yes, if you hurry, says the judge. Kyle McGee. Oh, my goodness. What a way to kick off the afternoon. Comes in with a massive super chat. Kyle, thank you for your generous support. That is absolutely huge. I'm not sure if there's supposed to be a comment with that, but I'd love to read it if you have one. Let us know in chat. That is massive, Kyle. Thank you. Sure, likely story, Ms. Moore. She was wrapping up her computer cords and everything long before Mr. Frog finished talking. She wanted to get out of there. I wonder if the victim hurt himself because intoxicated. Jamie, I suggested this right here as a possible scenario that might be a reasonable doubt, but not one that there is currently evidence to support. Does that make sense? I'm not saying that is what happened, but it's something that could have happened in the time frames we have and with the people that were there. And I mean, I've got to say, there's very little evidence to show, other than that there's blood on his clothing, that Mr. Ogletree caused the injury. Isn't it not just as likely that, if they did in fact smoke that synthetic heroin, whatever it was, or synthetic opioids, that there was a self-harm incident that went on, that somebody was quite literally banging their head against a brick wall. Is that not a possibility? And I'd say, arguably, yes, we've heard just as much evidence that could have happened as anything else, because we have nothing else to show that there was a physical beating other than a story from people who lie. Provably. I don't know. Let's see. Kiki's Garden, hello. Welcome. Thanks for gifting a membership. I went to Mr. Pancake. Congratulations. And Kiki OG, 27 months of support, giving out a membership in honor of Mr. Frog. Best news ever. How would you like to be the deputy that found him? He's like, "Oh, boss, you're never going to believe this. The guy?" He's like, "Oh, that guy? Yeah, I got him. He's in the back of my car." Mike gifted a membership as well. Congratulations, Miss Kitty. Since you try out all the other theories, just saying. Yeah. Let's see. Oh, Mike, thank you for your generosity, by the way. I'm sorry, I got carried up in a different comment. Legally Blonde, I think you might have some words that are getting caught by the filter. And it might have something to do with the word right before asphyxiation. Probably, well, it's not the word after erotic and not the word before fetish, but it's probably those two words that's getting caught by the filter. If I can just go ahead and make it quite clear. That's a bit much for the channel right now. Selena K gifted 5 memberships. Thank you very much, Selena, for your generosity. What happened to Le Plou? Pepe Le Plou? Not called by the defense. They said, cancel the transfer. We're not going to bring him over anyway.
Thank you. Please be seated.
Lena H. OG. Mr. Frog in a pink courthouse.
Step in the state rest.
Yes, Your Honor.
I was going to almost go to Mr. Oswald. Mr. Brennan, the defense rest.
Yes, Your Honor.
All right, ladies and gentlemen, at this time we have heard all of the evidence, and we are now going to the closing arguments of counsel. Ms. Nicholson?
Yes, Your Honor. Thank you. Ladies and gentlemen, you've now heard all of the testimony and evidence in this case. Let's talk about what we know the facts to be from what you've heard during the course of this trial. At 6:59 p.m., James Ogletree and Anthony Cummings meet up on the first range of J Block and spend a couple of minutes walking and talking. At 7:04 p.m., on December 6th of 2023, Marquise Wetherington can be seen for the last time alive on surveillance camera, peeking out of his cell, 2J3. at Lebanon Correctional Institution in Warren County, Ohio.
Thank you, Roro.
Seconds later, Anthony Cummings and the defendant, James Ogletree, can be seen entering cell 2J3 and sliding the door shut. At 7:11, Vincent Wicker knocks on the door of cell 2J3 after having been asked to be a lookout. Mr. Cummings, in response to that knock by Vincent Wicker, peeks out of the cell at 2J3 twice in quick succession, checking out the surroundings. At 7:11 and 7:13, Shaquiz Hakeem looks into the cell. And he told you that he saw Mr. Wetherington on his back on the bottom bunk with the defendant on top of him, strangling him. And he told you that he saw Anthony Cummings throwing some punches as well as going back and forth to the door like a lookout. At 7:14,
it's a lot in a very little time.
Anthony Cummings leaves with Marquise Wetherington's commissary bag, takes it to a cell on the other side of the range, and returns at 7:17. As Mr. Cummings is completing that task, the defendant is alone in cell 2J3 with the victim. And we know that Mr. Wetherington's commissary bag was never recovered. Moments later, Anthony Cummings and James Ogletree leave cell 2J3 and head in opposite directions. And at this time, blood is visible on the defendant's pants. The defendant and Mr. Cummings can be seen having multiple conversations shortly after they leave cell 2J3. First, here on the top range with Mr. Wicker, and then walking and talking on the bottom range. After the defendant and Mr. Cummings leave cell 2J3, 40 minutes go by before Mr. Wetherington's cellmate, Jason Addison, returns to the cell at 7:57. And he told you that he returned to his cell at that time because he had been approached by Anthony Cummings, who told him that he needed to check on his cellie because we beat his ass. You can see that conversation occur on surveillance video. And Jason Addison finds Mr. Wetherington face down on the floor, naked from the waist down, apparently unconscious, and his cell's a mess. And he immediately leaves. He doesn't know what to do, and he tells you he's not trying to have any part in what's going on.
There would have been blood everywhere.
11 minutes later, approximately, at 8:07, Jason Addison calls his girlfriend. A phone call that you heard, freaking out because people went into his cell and fucked my cellie up. Mr. Addison is again approached by Anthony Cummings, trying to check on the status of the victim. Mr. Addison told you he declined to clean the cell up for him, but agreed to help move Mr. Wetherington. So off to cell 2J3 they go at 8:12. Anthony Cummings and Jason Addison. They try to wake Marquise Wetherington up, which fails. And while they do get him onto the top rack, as Jason explained to you, Marquise never came to. He never woke up. He never was responsive. And while Mr. Addison admits he did not make much inquiry into how Marquise Wetherington was doing, he told you that he never knew him to be responsive or move around again after he entered the cell at 7:57. Consider Mr. Addison's appearance as they leave the cell at 8:15. Does that look like someone who just came from a cell where everything is fine? Lockdown is at 9 p.m. and while Mr. Addison tells you he attempts to alert a CO, corrections officers are not notified until approximately 7:42 a.m. on the morning of December 7th, when Corrections Officer Tyler Lay and Corrections Officer Jimmy Potts, after being alerted by inmate Glenn on the second range, find Marquise Wetherington unresponsive in the top bunk, which is covered in blood. We know that Marquise Wetherington was pronounced deceased at approximately 8 a.m. by Captain Corey Girdman. And we know from the autopsy that Marquise Wetherington suffered multiple blunt force injuries to his head, neck, chest, abdomen, and extremities. We also know that Dr. Brown found evidence of strangulation, a fact that was corroborated by what Shaquiz Hakeem told you he saw occurring in cell 2J3 as the defendant is over top Marquise Wetherington. And we know that the victim's DNA was found on both the defendant and Anthony Cummings on the clothing that they can be seen wearing in the surveillance footage. And as a result of all of those facts, James Ogletree is charged with 3 counts: felony murder, felonious assault, and aggravated robbery. In count 1 of the indictment, the defendant is charged with murder. Judge Teep is going to tell you that the state must prove, beyond a reasonable doubt, that on or about December 6th in Warren County, Ohio, the defendant caused the death of Marquise Wetherington as a proximate result of committing a violent felony, in this case, felonious assault. But before you can render a verdict on count 1, murder, you must first decide your verdict on count 2, felonious assault. Because remember, as we talked in voir dire, the defendant is not charged with purposeful murder or premeditated murder, but that felony murder. The death results from the commission of a violent felony. So let's look at the violent felony. In count 2 of the indictment, the defendant is charged with felonious assault. The state must prove to you beyond a reasonable doubt that on or about December 6, 2023, Warren County, Ohio, the defendant knowingly caused serious physical harm to Marquise Wetherington. Or he was complicit in causing serious physical harm to Mr. Wetherington. The judge is going to tell you that the defendant, for complicity, the defendant knowingly solicited, aided or abetted, or conspired with another to commit the offense of felonious assault. So you can find that the defendant committed the offense of felonious assault, or you can find that he aided and abetted his co-defendant, Anthony Cummings, in the commission of the offense. Remember the example from voir dire of all of the participants of a bank robbery. Not just the guy with the gun at the bank teller's head. The state doesn't have to show you that the defendant was the primary aggressor or the one that inflicted the most harm. Under complicity, you must find the defendant guilty of felonious assault if you find that he aided or abetted Mr. Cummings in the commission of a felonious assault. And what is the definition for aided and abetted? The judge will tell you that it means that he supported, assisted, encouraged, cooperated with, advised, or incited the principal offender to commit the offense. And the defendant has to share the criminal intent of the principal offender, which means that the defendant knowingly aided or abetted Mr. Cummings. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. And knowledge is determined from all of the facts and circumstances in evidence.
Reasonable
The state
minds
does
can
not
differ.
have to prove that anyone acted with the specific intent to cause a felonious assault. Only that they knew their actions could cause a certain result. The judge will tell you that you can infer the knowingly aspect from the circumstances surrounding the offense, including but not limited to presence, companionship, and conduct before or after the offense was committed. When you are present and participating in the kind of assault that obviously occurred in this case, based on the findings of Dr. Brown in the autopsy that was conducted. The defendant and Mr. Cummings would certainly have been aware that the result of their conduct could be serious physical harm. Serious physical harm means any of the following. Any physical harm that carries a substantial risk of death. Any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. And physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. Knowingly cause serious physical harm. We don't need to prove that the defendant intended to cause serious physical harm, or that he knew Anthony Cummings intended to cause serious physical harm. Only that he was aware that his actions, or those of his partner, could result in serious physical harm. And it's important to remember we're talking about knowingly committing or being complicit in the commission of a felonious assault. The serious physical harm, not the death of Mr. Wetherington. Ladies and gentlemen, you've seen the photographs of the victim's injuries. You've heard the coroner lay out the list of injuries the victim suffered at the hands of the defendant. This wasn't a one-punch situation. This wasn't quick. This was a brutal attack. And there is no question that the defendant and Mr. Cummings caused serious physical harm to the victim. And remember, the state doesn't have to show that the defendant was the primary aggressor or the only one that inflicted harm. Under complicity, you must find the defendant guilty of felonious assault if you find that he aided or abetted Mr. Cummings in the commission of a felonious assault. Here's what the evidence shows. The defendant and Mr. Cummings meet up on the first range at approximately 6:59 p.m., where they start talking, a conversation that lasts for a couple of minutes and includes a stop at a corner behind the stairs. The defendant and Mr. Cummings go into cell 2J3 together. Shaquiz Hakim observed the defendant strangling Mr. Wetherington, and he observed Mr. Cummings throwing some punches. When Mr. Cummings approaches Mr. Addison to tell him to check on his cellie, he tells him we just beat his ass. Not he, not they, not me. We. The defendant is in the cell for approximately 13 minutes. 2 minutes and 16 seconds of that, he is alone in cell 2J3 with the victim. Remember, this was a brutal assault. This was not quick. Mr. Wetherington suffered blunt force trauma to nearly his entire body. And while the defendant is alone in the cell with Mr. Wetherington, his partner steals Mr. Wetherington's belongings. Shaquiz Hakim told us that Mr. Cummings was a lookout. In between the punches, he'd go look out the door. Surveillance video confirms that. You can see him stick his head out a couple times, making sure they weren't going to be interrupted and they weren't going to be caught. He also waits for the okay from Mr. Wicker before leaving the cell. Why would one need to be a lookout but to ensure that what was occurring in the cell was not discovered? No question that when looking at all of the evidence together, the defendant committed the offense of felonious assault. You're not being asked to find whether the defendant was guilty as a complicitor. Complicity is merely a theory to assist you in your analysis of felonious assault. The judge is going to tell you that a person who is complicit with another in the commission of a criminal offense is regarded as guilty as if he personally performed every act constituting the offense. This is true even if he did not personally perform every act. If you find the state has proven beyond a reasonable doubt that the defendant committed or was complicit in the commission of the felonious assault, then your verdict on count 2 must be guilty.
Would Mr. Whitaker get the same thing?
So then we go back
then?
to count 1, felony murder. The only real question left for you to decide is whether the harm suffered by the victim as a result of the felonious assault was the proximate cause of his death. One way to look at felonious assault or felony murder is like an equation. Felonious assault plus a death equals felony murder. The death has to be a result of the harm suffered during the felonious assault. In this case, there is no question that the victim ultimately succumbed to the injuries he suffered at the hands of the defendant and Mr. Cummings. You heard testimony from Dr. Brown that clearly establishes that. She testified that he suffered from multiple blunt force injuries to the head, neck, torso, extremities, and showed significant signs of being strangled. The effect of the constellation of injuries resulted in the death of Marquise Wetherington. So if you find the defendant guilty of felonious assault, then he is also guilty of felony murder. Remember, this is not premeditated murder, it's not purposeful murder, and nowhere in the judge's instructions to you will you be required to hold the state to that standard. The state doesn't have to show that the defendant knowingly caused the victim's death. Only that they knowingly caused serious physical harm. And that serious physical harm resulted in the victim's death. In count 3 of the indictment, the defendant is charged with aggravated robbery. Judge Cheap will tell you that the state must prove beyond a reasonable doubt that on or about December 6, 2023 in Warren County, Ohio, the defendant, while committing or attempting to commit a theft offense, or in fleeing immediately after committing a theft offense, inflicted or attempted to inflict serious physical harm on Mr. Wetherington. The evidence has already clearly established the serious physical harm piece. So the only real question is, was a theft offense occurring? The evidence shows that on the evening of December 6th, Anthony Cummings took the victim's belongings and put them in a cell. Meanwhile, as Mr. Cummings is stealing Marquise Wetherington's property, the defendant is alone with the victim in his cell. You don't see Mr. Wetherington attempt to follow Mr. Cummings out, prevent him from leaving the cell, because he was unable to do so due to the physical assault he was suffering at the hands of the defendant who remained behind. Mr. Cummings never returned that property. You heard from the Highway Patrol it was never recovered. He didn't return it when the fight was over, not when he goes back into the victim's cell later, and not the next morning. That's a theft offense. Ladies and gentlemen, the state has met its burden and proven all of the elements of all 3 counts of the indictment to you beyond a reasonable doubt. Based on all of the evidence presented, the state is asking that you hold James Ogletree accountable for his actions on December 6th of 2023 that resulted in the death of Marquise Wetherington and return a verdict.
Thank you, Ms. Nicholson.
All right.
Apologies, Your Honor, I just need to.
You're on.
Just need to.
Ladies and gentlemen, the jury, I'm sorry about that. I'm having a little throat tickle issue. Try to work through it. So I talked to you at the very beginning of this case about reasonable doubt and the burden of proof, right? As we sit here, right, we do not have to prove anything. The state has to prove each and every element of the offenses that Ms. Nicholson just outlined here. They have the whole burden. So let's talk about what we've seen, what we've learned over the last couple of days. I think the one thing that virtually every witness agreed on, all the inmates, the EMTs, the medical staff, the Highway Patrol, is that Lebanon Correctional is a violent place. I believe Mr. Addison himself said, "We live in hell," or that may have been Mr. Wicker, one of his two. Somebody said, "We live in hell." Both Akeem and Addison said it was the most violent prison that they've been in. We heard reference to daily fights, assaults, robberies, beatings, drugs. Highway patrol, they said they respond hundreds of times. EMTs, he just indicated he just completed a report, over 70 calls per year. And that's a high level. That's just to the point where if the EMT is responding, as you heard him testify, there is such a medical emergency that the on-site staff can't handle that. Right? So we're talking about more than once a week. Right? We heard testimony about gang presence in the facility. Notably, we heard that Wicker and Addison are in the same gang. I think it's notable, Addison testified he had just been released from the hole, segregated housing. That's where you're placed for disciplinary reasons. Since this incident, he testified he's been transferred to a higher level security facility due to misconduct. I want to point your attention also, we heard quite a bit of testimony about the culture of silence, snitching, the ramifications of that, the consequences of that within the facility. Right. So if we look at the night in question, and you're going to have all the exhibits available to you, but if you look at the night in question, the very beginning of the second chunk of video, there's the chunk from 4 p.m. to 7 p.m., and then there's the chunk from 7 p.m. through the next morning on the surveillance video. Right around 7 p.m., we see the defendant, Mr. Ogletree, walk directly past Mr. Wetherington. Mr. Wetherington standing in the doorway to his cell. There doesn't appear to be any animosity. Doesn't appear, again, we don't have audio, but there doesn't appear to be any words exchanged. Right? There's no stare down. Right? There's no posturing. And the state would have you believe that just mere minutes after Mr. Ogletree harmlessly walks past him, right, he's then in the cell assisting in beating this man, ultimately what would be to his death. Right? There doesn't appear, we heard no testimony, there's no provocation, there's no issues between them, there's no problems, right? And again, I just want to point to that part of the video because I feel like it's extremely significant. Again, there's no encounter at all. It's just like any other two people on the range passing each other, right? And notably, who does not do anything like that, who you will not see on this video crossing paths with Wetherington until he enters the cell, Anthony Cummings. And again, you will have these exhibits available to you. You will pay attention, listen carefully. At 7:04:33, Cummings enters the cell first. We have seen the dimensions, or I think Trooper Creech testified to the dimensions of a cell. 6 by 10. We've got plenty of pictures of that cell. We've got beds on the one side. There's a shelving unit there. Right? These are 3 grown men. Cummings enters first. Right? There are pictures of that back corner of the cell. There's blood on the floor. There's a loose dreadlock. We don't know whose dreadlock that is. Why don't we know whose dreadlock that is? The Highway Patrol never bothered to recover it. They took a picture of it. They just let it lay there. Right? Take a look at State's Exhibit 47, the picture of Anthony Cummings. Look at his hair. Again, all of these individuals had dreads. We would put it to you that the most rational explanation of what happened inside of that cell, Cummings enters first. Cummings and Wetherington immediately make contact. They're in an altercation that ends in that back corner of the cell, where it is the kind of altercation that ends in somebody's dread being pulled or ripped out of their head. Right? Ms. Nicholson just argued that you can see Mr. Cummings in the doorway to the cell. We do not agree. I think it's not clear who that is. It's someone, right? It may be Mr. Ogletree, it may be Mr. Cummings, it could be Mr. Wetherington. We don't know. It's not clear because all you see is the barest glimpse of a profile and maybe a little bit of hair. It is not clear who that person is. I think it is most significant, right? We agree with the state that a robbery took place and that Mr. Cummings had accomplices. The question is, who were those accomplices? Right? Cummings is the one who takes the property. Not only does he take the property, he pretty much immediately, you can see it on the video, he pretty much immediately pays out his accomplice, Mr. Wicker. Mr. Wicker testified he got paid that day, same day. You know who didn't get anything? Mr. Ogletree. So the state would have you believe that this was an orchestrated robbery, that one of the primary participants somehow didn't get paid, right? Does that make sense, right? There are two people who point the finger at Ogletree. Mr. Cummings, Mr. Hakeem. Right? We heard testimony from Mr. Hakeem. Number one, he doesn't even remember, right? His testimony was discussed with him by the prosecutor. He was shown his earlier statement on a video, and he testified to that. He doesn't even remember what took place, right? But what he does remember is that he was Cummings' friend, right? The state would have us believe, right, that if we listen to what Mr. Addison said, that there was a board. He said that's some kind of a cover over the window, right? A shirt, a box, something. I think actually in one of the pictures you can see the door to 2J2. It's got like a little Debbie boxes up over it, right? Because you need a little bit of privacy. As you saw, the toilet's right inside the front door, right? But so they would have us believe that for some reason, while this robbery is taking place, no one bothered to cover the door, but then it's covered up later on, right? It's conveniently not covered up just in time for Mr. Addison, or I apologize, Mr. Hakeem, to look inside and to be able to conveniently demonstrate that, hey, it wasn't his friend who actually beat this guy up. It was Mr. Ogletree, right? Notably, when we talk about, accomplices and the robbery, right, not only is Mr. Wicker an accomplice here, right? He's the one who looked out, he knocked on the door, he instructed someone else to knock on the door. He got paid out some of these food items. Mr. Addison is an accomplice. Right? The state would have us sit here and rely on the statements of Mr. Addison as if he is completely reliable, as if he did not destroy important evidence that was never recovered. Right? We don't know what was taken to that trash can. We simply don't. It was never found. Right? There is no bedding on his bed. Right? No blanket, no pillows. We see him on the video walking some kind of I don't know if it's a blanket with other stuff wrapped in it. We don't know what it is because nobody ever found it, right? We see them walk that down, and who's on the other side of the range? Conveniently the next morning, Anthony Cummings. You know who's nowhere to be found? Mr. Ogletree, right? So this scheme here, right? We have Hakeem, we have Cummings, we have Addison, we have Wicker. Right. Mr. Ogletree, pay attention to his statements. The state is going to argue that these statements are some kind of a lie, some kind of a story that he made up. I'm going to put it to you this way. Right? There is a culture of silence in this prison. Right? There are ramifications for pointing the finger at somebody, for snitching. Right? Mr. Ogletree is desperately trying for about an interview and a half to avoid pointing the finger at anybody. Right? He doesn't know what happened. They were tuning, they were epping, whatever. Right? But we heard testimony from more than one witness, from the coroner who did the toxicology report, from Trooper Creech, that tune can be any number of things. Right? It may not be possible for that to show up. It might just be bug spray on paper. It may not be possible for that to show up on a toxicology screen. The state would have you dismiss any tune use, any drug use as impossible because there's nothing on the toxicology screen, right? But they're in that cell, right? We don't know what happened in the cell. The people who know what happened in the cell, Mr. Ogletree, Mr. Cummings, who's not here, Mr. Wetherington, who's tragically deceased, right? We don't know what happened. Here's what we know, right? Around 7:04, Mr. Cummings, Mr. Ogletree enter the cell. Mr. Ogletree, Mr. Cummings exit. Mr. Cummings exits at around 7:11. Mr. Ogletree exits several minutes later, right? And then about 40 minutes after that, Mr. Cummings and Mr. Addison enter the cell, right? And then ultimately the next morning dispose of something, right? We don't know what that is. What we don't know, it's never been able to be established, right, is cause of death or the time of death, right? And what time these injuries were inflicted. Right? We simply don't know. We don't know because Mr. Addison decided, I'm just going to sleep in this cell all night and not tell anybody about it. Right? We see on the video how many times there are COs walking past. Right? It's a completely separate individual who finally alerts the staff, right? Hey, there's something wrong up here. I'm going to point your attention to around 7:03 a.m. You can see Mr. Addison is standing in the door to his cell. A CO walks directly past him. He doesn't say anything. Right. And again, I want to circle back to Mr. Ogletree's statements. Right. He's talking about tune use. Right. And I would argue that when we look at, those statements, we look at the video, right? We look at the fact that right around 7 p.m. before they enter the cell, he just walks past Mr. Wetherington, like nothing's going on, right? That he and Mr. Cummings are talking about using tune in that cell, right? There's nothing to indicate that that never happened, right? There's nothing. And I would argue, right, we look at the first statement, the December 7th statement, and he's talking about lunch. I believe that it's possible that lunch and dinner were mixed up, right? You're in prison. This was shortly after chow, as multiple inmates and staff indicated, right? You're in prison, the days run together, you mix up your meals. It happens, right? The second day, right, the second statement, I really want to point your attention to the second interview, right? Mr. Ogletree is consistently, I counted on about 12 different occasions throughout the transcript. Mr. Ogletree consistently talks about there being dreads on the floor. He tells the investigators that. There is a dread on the floor. We know that. We've seen it. It's in the photos, right? They never follow up on that, right? That is a consistent statement with the evidence in the case that was never followed up on, that was never investigated. Right? It is the responsibility of law enforcement to investigate these cases and the responsibility of the state to present them in court like we're doing here today. Right? There was evidence in this case that was not followed up on, right? That wasn't investigated. Right? That dreadlock could have very easily been sent off to BCI to be tested, right? It's laying in blood. Again, look at the picture of Mr. Cummings. Look at the dreadlock on the floor, right? Ultimately, Mr. Ogletree, again, not only is he talking about dreads, he's talking about how he stuck around to try to help, right? The state's going to have you believe that this was some kind of an orchestrated robbery that didn't ultimately result in Mr. Ogletree receiving anything, right? Where Mr. Ogletree, his story is that he went into the cell to smoke tune, right? Somebody gets hurt, he helps out. He's not trying to get in any trouble. He's not trying to get anybody else in any trouble. He's trying to go along to get along, right? Which again, more than one inmate referred to this place as hell, right? Going along to get along seems like a pretty good strategy for survival in a place like that. Right? He's got blood on him. He helped Mr. Wetherington, right? He's in the cell. He's getting him up, getting him around, whatever. We don't know what happened. We don't know how severely or not severely he was beaten. We don't know if he fell. What we do know is that there's a dent on that shelving unit, which appears to be some kind of metal, right, with some blood splatter on it. There's blood in that back corner, right? It's kind of like a little splayed out pattern. Right? Did he hit his head on the floor? Did he hit his head on the shelf? Right? Mr. Addison, who again covered up quite a bit of evidence, so I'm not sure why we should just rely on everything that he says is accurate. But Mr. Addison said that he found him at least naked from the waist down. He said he didn't remember what he was wearing, but naked from the waist down on the floor, right? Is it possible that Mr. Wetherington got up to use the bathroom? Because again, there was an indication that the door was covered up and fell and hit his head. We don't know. Because again, the coroner's not able to establish what time these injuries took place. There are multiple people in this cell. Mr. Cummings, who again is the one who actually robbed Mr. Wetherington. Mr. Cummings goes back in the cell and is in there for a number of minutes, right? Mr. Addison testified, hey, we're gonna move him up on the bed. Why are they moving him up on the bed instead of getting help? To cover up what happened, right? Again, Mr. Ogletree received no property. No one testified to that. No one recovered anything. No one found anything in his cell. In his statement to investigators, he indicated he doesn't need to rob anybody. If he wants some food, he'll just ask somebody for it, right? The state would have you believe, again, that he participated in this robbery that resulted in Mr. Wetherington's death without actually getting anything out of it, right? So that would lead us to conclude, right, that either Mr. Ogletree is completely incompetent or he's roughly an innocent bystander in all of this, right? The state talks about, and I'm sure you're going to hear it again, right, the bank robbery.
And pause.
Getaway driver is just as guilty as the people in the bank, right? Let's elaborate on that, right? So if this is a bank robbery, Cummings is the one who took the stuff out of the safe, right? Addison is the bag man helping clean up after the fact, right? Wicker's the lookout. And Hakeem is the alibi guy, right? Hey, he didn't do it. Ogletree did it.
Ogletree's
yeah,
the
my
fall
buddy,
guy?
he's innocent. He wasn't doing anything in there. Right? What the state has demonstrated that Mr. Ogletree is guilty of is being in that cell and having blood on his clothes. Again, we don't know what caused those gashes to the side of his head. We don't know what caused these injuries. We simply don't. And the reason is, again, because he was in that cell for 12 hours. Right? Again, Mr. Addison says he was completely non-responsive when he went in the cell. And Mr. Addison, again, admitted to being a gang member, right? Also destroyed, disposed of, covered up quite a bit of evidence. And ladies and gentlemen, the jury, ultimately, right, the actions that the state is going to present as suspicious, right? Mr. Ogletree walking around talking to Mr. Cummings, right? He's walking around the block. You see him talk to a large number of people. Right? Ultimately, all of his actions can be explained, right? If we just assume that he's going in that cell to smoke tune, right? We heard that's banned, right? You get in trouble administratively, you get charged with a felony for that, right? Trooper Creech testified about his role in investigating drug possession, right? That is also illegal. And that can explain virtually all of this suspicious behavior beforehand. And I think, again, I want to point, before I finish up here, I want to point your attention to the dreadlock, right, that was never followed up on, despite, again, Mr. Ogletree mentioning it 12 times in his interview. Hey, there's dreads on the floor, you know, that was crazy, hair was flying. He says stuff, and he says something along the lines of, you know, people's dreads were all over the floor, you know, he mentions it many, many times, right? That was never followed up on. You see, when you watch that video, there are people everywhere, right? It's a crowded cell block, right? There's 200 people on it, we heard. There's people roaming around, walking back and forth. They're the dude in cell 2J2, right next door, he's leaning out of his cell while the state would have you believe that there's a violent assault happening next door, right? He told investigators he didn't hear anything, he's not here to testify, the state didn't bring him in, right? I mean, he didn't hear anything, at least I would think that if he did, they would have brought him in to have him testify, right? I mean, there's people constantly walking past that cell. The only one who said anything, conveniently, Mr. Cummings' friend, right? There are other people, you'll see them, watch the video, right? The guy in the green sweatshirt, there's a gentleman with a pretty big afro who stops by the door for a couple of minutes at one point. Where are these people, right? What do they have to say? What were their statements? why weren't they here today? Right? If Mr. Ogletree did in fact, right, participate in this robbery, injure this man that ultimately led to his death, right? Why were all of these people not brought in here? Right? This isn't a case where, hey, we don't know where they are. We know where they are. They're in prison, right? You could not have an easier way to track down witnesses, right? They're not here. Nobody else saw anything. The only person who points the finger at Ogletree is Akeem, right? Cummings' his friend. Take a look at the statements, right? They asked Mr. Ogletree, hey, why would Mr. Cummings, lie about that? Say, hey, he wants to get out of jail, right? Everyone wants to avoid trouble. But again, look at the evidence, look at the video, listen to the statements. You will have all of this available to you. Everything that was an exhibit, you will have available to you, right? Just like I said at the beginning of this case, look and listen. It is not as open and shut as the state would have you believe, right? Again, these are serious injuries that we don't know when they were inflicted. We don't know how they were inflicted, right? We don't know whether they happened at 7:10, 7:50, overnight. We have no idea. What we do know is the state is completely relying on information that they got from people who we can witness disposing of evidence, right? Mr. Ogletree received no property. He left that cell with no property. After the incident, he's walking around. It's not like he just spent the rest of the night in the cell. He's walking around, right? He goes down to the showers. He's walking around. He's talking to people. He changes clothes. If he was going to get paid out, ample opportunity to do that. He talks to Cummings more than once, right? Ample opportunity to pay him out, just like Mr. Wicker got paid out. Why does that not happen? Because Mr. Ogletree was not in on this scheme. He was trying to smoke, right? And so ultimately, ladies and gentlemen of the jury, look through the evidence with an open mind, look carefully and closely, and we would argue that at the conclusion, you must find him not guilty of these charges. Thank you.
Thank you, Mr. President. Mr. Knippen.
Thank you, Your Honor.
They bifurcate the closing. What? No.
Ladies and gentlemen, this is not a complicated case.
Ask me if I want to say something.
You just need to use your common sense. When the defendant and Mr. Cummings enter the cell at 2J3, Mr. Wetherington was alive, he was healthy, and he had been standing at the door just moments before. 14 minutes later, when the defendant and Anthony Cummings leave that cell, they are covered in the victim's blood, and Mr. Wetherington is incapacitated on the ground, unable to get up, move, or even talk. From that moment on, Mr. Wetherington never again shows any signs of life. This is not complicated to figure out what happened. You know exactly what happened in that cell. And all of the evidence establishes beyond a reasonable doubt that both Cummings and the defendant violently assaulted Mr. Wetherington and stole his belongings. When you're evaluating this case, I want you to consider the different types of evidence that the state has presented. And there are 3 different types of evidence that were presented in this case that are really undisputed. And that is the video evidence, that is the medical evidence, and that is the forensic evidence. And so when you're considering everything else, when you're considering the testimony of the witnesses or the story of Mr. Ogletree, I want you to evaluate it through that lens and see how it matches up to really the undisputed evidence, the evidence that's not really contested, which is, again, the video evidence, the medical evidence, and the forensic evidence. Because the video evidence, that's number 1, it establishes a timeline in this case, and it conclusively establishes who entered cell 2J3. But not only does it establish a timeline, it shows you the movements and the locations of everyone involved in this case. Ms. Nicholson went through that with you. And so I'm not going to rehash all of the different movements throughout the process, but we know that the video evidence is undisputed because it speaks for itself. The second type of evidence that's undisputed is the medical evidence. This includes the autopsy results and the injuries that were sustained to the victim. You yourselves were able to view and see the injuries that Mr. Wetherington had. And you heard Dr. Brown testify about all of those injuries that the victim had sustained. Multiple blunt force trauma, to include blunt force trauma to the head, bruising to the face, neck, lips, and scalp, abrasions to the forehead and lips, lacerations to the scalp, internal bleeding around the brain, contusions to the chest and the abdomen, bruising to the right forearm and thighs, abrasions to the right arm, right knee, and right leg, as well as signs of strangulation, including petechiae surrounding both eyes, and bruising to the anterior neck, and bruising even to the internal soft tissue of the neck. So again, that's another type of evidence that's not really in dispute. You heard the testimony from Dr. Brown. And then the third type of evidence that's not really in dispute is the forensic evidence, or the DNA evidence. And the forensic evidence establishes that both the defendant and Cummings had the victim's blood and DNA all over their clothing. You saw the thermal pants that Mr. Ogletree was wearing, and you saw the sweatshirt of Mr. Cummings. You saw those blood stains, and you heard forensic scientist Catherine Daly testify that those stains on the defendant's clothing had the victim's DNA on them. So again, think about that evidence. All of that evidence, undisputed. Video evidence, medical evidence, and forensic evidence. And the state would submit to you that if you just look at that evidence by itself, that is enough to prove that this defendant committed these crimes beyond a reasonable doubt. But that's not the only type of evidence that we presented. We presented one additional type of evidence, and that was eyewitness testimony. That eyewitness testimony was presented by Shaquiz Hakeem, Jason Addison, and Vincent Wicker. And here's what I want you to ask yourself when you're evaluating the eyewitness testimony of these individuals. This is what I think is important for you to be thinking about when you're trying to decide whether they're credible or not. I want you to compare their testimony and the statements that they made to the three types of undisputed evidence, to the video evidence, to the medical evidence, and to the forensic evidence. And I want you to consider, is their testimony supported and corroborated by that undisputed evidence, or is it contradicted by that evidence? And then we're going to do the same thing with Mr. Ogletree's statements and evaluate it through that same lens. So let's first talk about Shaquiz Hakeem. Shaquiz told you when he looked into that cell at 2J3, he saw the defendant on top of the victim on the first bunk, and that the defendant was punching him and choking him. He also testified that he saw Cummings punching the victim and looking out the window to see if anyone was coming. So you first have to ask yourself, when you're evaluating Shaquiz's testimony, did he even have an opportunity to see the things that he told you that he saw? And we know from the video evidence, as Ms. Nicholson showed you, he absolutely had the opportunity to see the things that he's telling you that he saw. You saw him go right up to that window, look directly inside, right where he'd be able to see both beds, and he'd be able to see exactly what was happening in there. So his testimony is supported by the video evidence when he's telling you that he was looking inside of that cell. So then I want you to ask yourself, is his testimony also supported by the medical evidence, i.e. the injuries to the victim? And this is how I think you can actually tell and know for certain that Mr. Hakeem was telling you the truth. And you can know that because he told you from the witness stand, and he told Trooper Creech the day after this incident occurred, that James Ogletree was on top of the victim and he was choking him. That James Ogletree was choking the victim. Shaquiz Hakeem would have no way of knowing that later on when an autopsy was conducted on Mr. Wetherington, that there would be evidence of strangulation, that the victim would have petechiae, that he would have bruising to the external part of his neck, and also that he would have bruising to the internal soft tissue of his neck. Mr. Hakim would have no way of knowing that. He is the only one that provides evidence of how those injuries to the neck of Mr. Wetherington would have occurred. And so that's how you know you can believe his testimony, because it's supported by the video evidence and it's supported by the medical evidence. But not only that, it's also then supported by the forensic evidence. Because if you believe Shakiza's testimony, it would make perfect sense then why Mr. Ogletree's would have the victim's blood all over his clothing. So when you look at the undisputed evidence, Shakiza Keem's testimony is supported by all three types of that undisputed evidence.
The defendant's really mad with his attorney right now. Not happy with what he said. He wanted
the defense
something
wanted to talk
said.
about, well, he got an opportunity to review his video before he testified. But think about that. That's not unusual at all. If anybody sees an event and they give a statement to the police, and then 2 years pass before they have to come into a courtroom and swear under oath that what they're going to tell is the truth, anyone would want to see that statement that they made 2 years prior to make sure that it's the same and consistent and that they remember everything that they told the trooper. That's not unusual at all. Think about if any officer, now all the officers have body-worn camera, and the officers have the ability to access that camera. If a case takes 2 years to be presented to a jury, an officer would go back and review that body-worn camera because they want to be accurate. There's nothing unusual about that at all. It's not odd that someone would go back and watch that testimony before coming in and testify. But remember, he made those statements the day after this incident occurred. And one of the jurors asked a question like, were those statements consistent? And Trooper Creech said that they were.
The prosecutor turned and faced the
Now
defense
let's talk
table.
about Mr. Addison.
His voice triggered the camera
He
switch.
told you that he was not in the cell when this occurred, and that Anthony Cummings approached him and told him he needs to go check on his cellie. And he told you that he opened the door and that he saw the victim beaten and unconscious lying on the floor. He later told you that after he exited the cell, Mr. Cummings asked him to help clean it up, and the two of them went into the cell together and lifted the victim up onto the rack. Again, all of this testimony is supported by the video evidence.
The judge is going to tell him to shut up here in a minute.
Jason Addison first walks into that cell at 7:57. You see him come back, and you see him and Anthony Cummings then enter that cell later, I believe at approximately 8:12. All of that is captured on video. Everything that he's saying lines up. But not only is his testimony supported by the video evidence, it's also supported by the medical evidence. Because Mr. Addison talked about the victim being knocked out and unconscious and never showing any signs of life during their entire interaction. This is consistent with the medical evidence and the injuries we know that the victim sustained, as testified to by Dr. Brown. And how else do we know that Jason Addison was telling you the truth? We know that because just 10 minutes after he entered that cell for the first time, he is on the phone with his girlfriend talking about how two dudes just went in there and fucked up his cellie. Think about that. Just 10 minutes after he enters that cell, we have him on a recorded phone call talking to his girlfriend, telling her exactly what it is that he saw. That's how you know that Mr. Addison wasn't involved. The video evidence confirms he wasn't in the cell at the time of the attack, and the phone call that evening to his girlfriend confirms just how badly the victim was beaten by the defendant and Mr. Cummings. So Mr. Addison's testimony is supported by the video evidence, it's supported by the medical evidence, and it's supported by the recorded phone call that he made to his girlfriend. And Mr. Addison's testimony tightens that timeline, doesn't it? Because we know the video evidence from the video evidence that after the defendant and Cummings leave the cell at 7:17, no one enters that cell until Jason Addison goes in at 7:57. And then just 10 minutes later, we have that recorded phone call to his girlfriend where he's telling her exactly what he saw. To think that Jason Addison was involved in this, you would have to think that he was smart enough to think all this through and plan all this out, to place this phone call to his girlfriend when he was secretly involved in this, or secretly somehow went back in later on or overnight and attacked the victim. That's not realistic. Jason Addison is not that smart. He's not going to come up with that, ladies and gentlemen. Now, what is Jason Addison's fault? What is his flaw in all of this? There's no question Jason Addison, over the course of that night, should have alerted a CO, should have done a better job to get a CO, to get in there and help Mr. Wetherington and see if he could have been revived at that point. That's a fact. There's no getting around that. He should have done better. That was a moral failure on his part, and he failed it epically. But that doesn't change what this defendant and Anthony Cummings did to Mr. Wetherington. Finally, you have the testimony of Mr. Wicker, and he stated that he was asked by Mr. Cummings to watch the door and alert them if any COs were approaching. And he told you that when he knocked on the door, he looked inside, and he saw 3 big dudes in there tussling. Again, even his evidence, or his testimony, is supported by the video evidence. You can clearly see him acting as a lookout. You can clearly see him knock on the door and look in, and then you can see him walk away. Was he more involved? I don't know. But we know from the testimony that everything that he told you is corroborated by the video evidence. So the testimony of all 3 eyewitnesses are supported by the undisputed evidence, the video evidence, the medical evidence, and the forensic evidence. One other thing that I think is important to mention is the risk that these individuals took by coming in here and testifying to all of you. There's been testimony about a code and a culture, and you're not really supposed to snitch. But these individuals, all 3 of them, the day after this incident, they came in and they told Trooper Creech exactly what they saw. But not only that, they came into this courtroom and they got up on that witness stand in front of Mr. Ogletree, and they told you the same thing that they told Creech back on December 7th about what they saw. They took a real risk by coming in here and testifying. They're breaking a code when they do that. You're not supposed to do that. And you could tell especially from Mr. Hakeem, and you could tell from Mr. Addison that they did not want to be here. They said that. Mr. Hakeem said, I don't want to be here. And you could tell from Mr. Addison how scared that man was when he was testifying. But what did Mr. Addison tell you? He said that he was doing it because what he observed and what he saw, what they did to Mr. Wetherington just wasn't right. So he came in here, and at his own peril, at all of their own peril, they came in here and testified truthfully about what they saw. Mr. Brenner talked a lot about this dread that could have, should have, would have been collected. Should the Ohio State Highway Patrol have collected that, what appears to be a dread? Yes, absolutely, they should have collected that. Is there anything that we can do about it now?
It was most likely Mr. Wetherington's.
No, there's not. Do we know whose dread that was? We don't. They all 3 had dreads. It could have been Mr. Ogletree's dread, could have been the victim's dread, could have been Mr. Wetherington's dread.
He was the victim.
But even if we knew whose dread it was, it doesn't change anything from the state's perspective. Because this was a beatdown. The 2 of them went in there together. They assaulted the victim together. They both have the victim's blood all over their clothing. So whether Mr. Wetherington, while he was trying to fight back, was able to pull Mr. Cummings' dread off, or whether he was able to pull Mr. Ogletree's dread off, or maybe one of them pulled Mr. Wetherington's dread off, it doesn't change. It doesn't matter. It doesn't change what happened to Mr. Wetherington in that cell. So I wouldn't get too focused on the dread. The other thing that I want to touch on briefly is this aggravated robbery and the idea that Mr. Ogletree didn't get anything. Whether he got anything or not is not important to whether he was complicit in committing the aggravated robbery. If Mr. Cummings is able to get the victim's commissary bag and walk out of it, and walk out of the cell with it because of the assault that Mr. Ogletree and Mr. Cummings had put on him, or whether because Mr. Ogletree was still assaulting the victim at the time that Mr. Cummings walked out of the door with that bag, that's complicity to aggravated robbery. So it doesn't matter whether he got something, whether he didn't get something. If by aiding and helping and encouraging and by assaulting the victim, Mr. Cummings was able to walk out of the cell with that bag, he is just as guilty of the aggravated robbery. One of the last things I want to do with you, ladies and gentlemen, is I want to go back to that lens through which I'm asking you to look at every piece of evidence in this case, compared to the video evidence, medical evidence, and forensic evidence. We did that with the state's witnesses. Now let's do that with Mr. Ogletree's story to the detectives, or to the troopers. If you remember, during that first interview with Trooper Clance, the defendant stated 3 critical facts that I want you to pay attention to. First, he stated he did not enter the victim's cell after lunchtime. He was asked several times about that in several different ways, and he says, I did not enter that cell after lunch. And we know, well, we'll come back to that. The second fact is, he stated that the victim was just epping, and that there was no fighting while he was present in the cell. And third, he confidently stated that the victim's blood and DNA would not be on his clothing. So those are 3 statements that he made. There was no fighting, there would be no blood on his clothing, he wasn't in that cell after lunch. Now let's compare that to the undisputed evidence that we know in this case. We know that the statement about I wasn't in that cell after lunch was false. We know that from the timestamp on the video. He was in there at 7:04 p.m. So that was a false statement right away that he made to the police. So the video evidence contradicts what he said. Second, the medical evidence shows that he was not being truthful. There's no way that that victim was just epping and falling over, and that's what caused all of these injuries. You heard Mr. Brenner try to ask that a bunch of different ways to the coroner, to Dr. Brown, and be like, well, if he fell, if he was epping and he kind of fell out of bed, could that have caused it? And Dr. Brown was adamant. She's like, that couldn't have happened because of the constellation of injuries. Because he was beaten so badly, we're not talking about a single injury. We're talking about injuries to all over his head. You're talking about injuries to his body, to his chest, to his legs. And you're talking about injuries to his throat where he was strangled. This wasn't a situation where this person was just epping and fell over a couple of times. This was an assault. And Dr. Brown's testimony confirms that this was an assault and shows that Mr. Ogletree's statement to the police is unquestionably false. And then the last thing that shows that his statements are false is the forensic evidence. He was adamant. There is no way that that victim's blood is going to be on my clothing. Not his blood, not his DNA. Felt pretty confident saying that because he had changed his clothes, because he knew that his actual clothes that he wore during the assault were in his trash can. He didn't know that the troopers were going to go and find that clothes in his trash can, which unquestionably showed blood all over his pants and on the top of his sweatshirt. So again, his initial statement to the police is contradicted by all of the undisputed evidence. It's contradicted by the video, by the medical, and by the forensic evidence. And now Mr. Brenner wants you to believe, well, maybe he just wasn't telling the truth because he was afraid of snitching. He didn't want to get hurt. Ladies and gentlemen, there is no evidence in this case of that whatsoever. In fact, the only evidence that we have completely refutes that. Because if you remember, when Mr. Ogletree was asked if he was afraid of fighting anybody in the jail or in the prison, he said that he wasn't. He says nobody messes with him. Nobody fights with him. He's 6'3". He is a big dude. He made it sure that he could handle himself. So he's not worried about coming back and somebody being mad at him for giving a statement to the troopers.
The defendant
now
is
let's
getting
talk about the
agitated.
second interview. where the defendant continues with his lies, still claiming initially that the victim was Epping. But it's not until Trooper Butler and Trooper Creech start pushing him and start talking about all of the other evidence they had. They start talking to him about the video evidence, the blood on the thermals, and the injuries from the autopsy. And as the defendant is confronted with this mountain of evidence against him, he, at the very end of that interview, tries to gently point the finger at Anthony Cummings. And he claimed that Mr. Cummings was tussling with the victim and he himself was just in there smoking too. But even think about that and whether that story makes sense. Think about the injuries that you know that the victim suffered. That was a complete beatdown that Mr. Wetherington suffered in that cell. And apparently, Mr. Ogletree wants you to believe that while Anthony Cummings was assaulting him and causing every single one of those injuries to Mr. Wetherington, he's just off in the corner, smoking his tune, getting high. Does that make sense? Is that logical at all? Of course not. And then this is the most offensive part. He wants you to believe that as Mr. Cummings exits the cell and he takes the victim's commissary bag, we know that he's in there for 3 minutes. 3 additional minutes. But what does he want you to believe that he was doing during those 3 minutes? He wants you to believe he was the one that was helping him. I was concerned about Mr. Wetherington. I was trying to help him and get him up and take care of him. That's absurd, ladies and gentlemen. It defies all reason and common sense. But don't get me wrong, it's smart to try to pin this on Anthony Cummings if you're Mr. Ogletree. Cummings was definitely involved. There's no question about that. He stole the commissary bag while the defendant was still in there assaulting the victim. But to try to suggest that Cummings did this alone begs absurdity when the video evidence shows them hanging out before and after the assault, and both of them are covered in the victim's blood. And remember, we don't have to prove that James Ogletree acted alone in this matter. We don't believe that's the case at all. It's the state's position that they were working together. And that's why you're going to be instructed on complicity. Because complicity, under that theory, the defendant is just as guilty of all of these offenses if you believe that they were working together and that the defendant was encouraging, supporting, or assisting in any way all of these offenses that were committed in the cell. Ladies and gentlemen, as I told you at the beginning, this is not a complicated case. The victim was alive and well before being confined in that cell for 14 minutes with the defendant and Cummings. Both the defendant and Cummings then exit the cell, covered in the victim's blood. And the very next person to
little hiccup on the
find the victim
stream
and unconscious on the cold concrete floor. Use your common sense. Evaluate all of the testimony and evaluate the defendant's stories through that lens of, is it consistent or contradicted by the undisputed evidence in this case, by the video evidence, by the medical evidence, and by the forensic evidence. And once you do that, you will come to but one conclusion, that the defendant is guilty of felony murder, felonious assault, and aggravated robbery. Thank you,
big
ladies
finish.
and gentlemen.
Remember, we approach very quickly.
Yes.
We have an issue, says defense. We have an issue. A big issue, which is not very timely. We'd like to testify. We'd like to testify. I think that's what he's going to say. Let's see. We've got 25. Let's go up to 26 on our counter. We've been put in timeout, private time, a couple times here today. This one might be a little bit longer. I don't know how. For those that are watching, the show was not what was happening at the lectern. The show was what was happening at the defense table during that closing for the state, the rebuttal. From what we could just glean a little bit, there was something the defendant either wanted to say or wanted to have said that he feels very strongly about that wasn't said. And it's over. Defense is over. That their time to talk to the jury is gone. Now, you might realize that in this trial, we did not have a moment where the judge talked to the defendant and said, "Would you like to testify?" That doesn't happen in Ohio.
Members of the jury, you have heard the evidence and the arguments of counsel, and it is now my duty to instruct you on the law.
It's my duty.
The court and the jury have separate functions. You decide the disputed facts, and the court provides you with the instructions of law. It is your sworn duty to accept these instructions and apply the law as I give it to you. You are not permitted to change the law or to apply your own idea of what you think the law is or ought to be. Now, the case before you began with the filing of an indictment. The indictment informs the defendant that he has been charged with a crime. You may not consider the fact that it was filed for any purpose. A plea of not guilty is a denial of the charges and puts at issue all of the essential elements charged in that indictment. The defendant is presumed innocent until guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offenses charged. Reasonable doubt is present when you, after having carefully considered and compared all the evidence, cannot say you are firmly convinced of the truth of the charges. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. So the evidence is all the testimony received from the witness stand and the exhibits admitted during the trial. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all of the elements beyond a reasonable doubt. Direct evidence is the testimony given by a witness who has seen or heard the facts about which the witness testifies. It includes exhibits admitted into evidence during the trial and stipulations that you were instructed to accept as fact. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts that naturally and logically follow according to the common experience of people. Direct evidence and circumstantial evidence are of equal weight. Direct evidence and circumstantial evidence possess the same probative value. In some instances, certain facts can only be established by circumstantial evidence. A conviction based solely on circumstantial evidence is no less sound than a conviction based on direct evidence. To infer or to make an inference is to reach a reasonable conclusion of fact that you may, but are not required to make, from other facts that you find have been established by direct evidence. You may infer a fact or reach a conclusion only from other facts that have been proved by direct evidence. Whether an inference is made rests entirely with you. The evidence does not include any statements made by counsel during the trial unless the statement was an admission or agreement of certain facts. The opening statements and closing arguments are not evidence. They are designed to assist you in evaluating that evidence. The evidence does not include any statements that were stricken by the court or that you were instructed to disregard. You must not speculate why an objection was sustained to any question or what the answer to that question might have been, because these are questions of law and rest solely with the court. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the believability of the witnesses, and to do this, you will use the tests of truthfulness that you use in your daily lives. These tests include the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests and assign to each witness's testimony such weight as you think proper. You are not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. The testimony of a law enforcement officer is to be weighed by the same rules that apply to other witnesses. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that he did not testify must not be considered for any purpose. Now, generally, a witness may not express an opinion. However, someone who follows a profession or a special line of work may express her opinion because of her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. Questions may have been asked in which an expert witness was presumed to assume that certain facts were true and to give an opinion based upon such assumption. You must determine whether the assumed facts upon which the expert based the opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the expert. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of any expert. In determining its weight, you may take into consideration their skill, experience, knowledge, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. Now, a number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects and in the same condition as when they were originally taken. You will determine what weight, if any, the exhibit should receive in light of all the evidence. Audio tape and videotape recordings and testimony relating to each have been introduced into evidence. You shall consider whether the audio tapes and videotapes are a true record of what transpired at the time they were taken. If you find that they are, you will then determine what weight, if any, the audio tape and videotapes should receive in light of all the evidence. Now, the defendant is charged with murder. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 6, 2023, and in Warren County, Ohio, the defendant caused the death of another as a proximate result of committing or attempting to commit an offense of violence that is a felony, and in this case, felonious assault. Before you could find the defendant was committing or attempting to commit felonious assault, you must find beyond a reasonable doubt that on or about December 6, 2023, and in Warren County, Ohio, the defendant knowingly caused or attempted to cause serious physical harm to another. The state charges that the act of the defendant caused a death. Cause is an essential element of the offense. Cause is an act which in a natural and continuous sequence directly produces the death and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. If you find the state proved beyond a reasonable doubt all the essential elements of murder, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of murder, then your verdict must be not guilty. The defendant is also charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 6, 2023, and in Warren County, Ohio, the defendant knowingly caused serious physical harm to another. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person subjectively believes that there is a high probability of its existence and fails to make inquiry or acts with a conscious purpose to avoid learning the fact. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that a felonious assault would occur. An attempt occurs when a person knowingly engages in conduct that, if successful, would result in serious physical harm. Serious physical harm to persons means any of the following. Number one, any condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. Number two, any physical harm that carries a substantial risk of death. Number three, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. Number 4, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement. And number 5, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. Now, the court has previously defined natural consequences, and that definition shall also apply here. If you find the state has proven beyond a reasonable doubt all of the essential elements of felonious assault, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of felonious assault, then your verdict must be not guilty. As to count 3, aggravated robbery, the defendant is charged with aggravated robbery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 6, 2023, and in Warren County, Ohio, the defendant, while committing or attempting to commit a theft offense or in fleeing immediately after committing a theft offense upon another, inflicted or attempted to inflict serious physical harm on the other. Before you can find that the defendant was committing or attempting to commit theft, you must find beyond a reasonable doubt that the defendant, with the purpose to deprive the owner of property, knowingly obtained or exerted control over the property without the consent of the owner or person authorized to give consent, or by deception, threat, or by intimidation. Purpose is an essential element of the crime of theft. A person acts purposely when it is the person's specific intent to cause a certain result or engage in a conduct of a certain nature. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to obtain or exert control over either the property or services without the consent of the owner or person authorized to give consent. Property means any property, real or personal, tangible or intangible, and any interest or license in that property. Deprive means to do any of the following: withhold property of another permanently, or for a period that appropriates a withhold property of another permanently or for a period that appropriates a substantial portion of its value or use, or with purpose to restore it only upon payment of reward or other consideration. Dispose of property so as to make it unlikely that the owner will recover it. Accept, use, or appropriate money, property, or services with purpose not to give proper consideration in return for the money, property, or services, and without reasonable justification or excuse for not giving consideration. Consent may be either express or implied. Express consent is determined by the written or spoken words of the persons involved. Implied consent is determined by the facts and circumstances that surround those involved, including their words and acts, from which you may infer that consent was given to the defendant. The court has previously defined knowingly, attempt, and serious physical harm, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all the essential elements of aggravated robbery, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of aggravated robbery, then your verdict must be not guilty. The state has presented a theory that the defendant acted in complicity with another in the commission of murder, felonious assault, and aggravated robbery. A person who is complicit with another in the commission of a criminal offense is regarded as guilty as if he personally performed every act constituting the offense. This is true even if he did not personally perform every act constituting the offense or was not physically present at the time the offenses were committed. Before you can find the defendant guilty of complicity in the commission of murder, felonious assault, and/or aggravated robbery, you must find beyond a reasonable doubt that on or about December 6, 2023, and in Warren County, Ohio, the defendant knowingly, with respect to felonious assault, or purposely with respect to aggravated robbery, solicited, aided, or abetted, or conspired with another to commit the offenses of murder, felonious assault, and/or aggravated robbery. The court has already defined knowingly, purposely, and explained all the elements of the underlying principal offenses of murder, felonious assault, and aggravated robbery above, and those definitions shall also apply here. Solicit means to seek, to ask, to influence, to invite, to tempt, to lead on, to bring pressure to bear. Before you can find the defendant guilty of complicity by aiding and abetting, You must find beyond a reasonable doubt that the defendant supported, assisted, encouraged, cooperated with, advised, or incited the principal offender in the commission of the offense, and that the defendant shared the criminal intent of the principal offender. Such intent may be inferred from the circumstances surrounding the offenses, including but not limited to presence, companionship, and conduct before and after the offenses were committed. The mere presence of the defendant at the scene of the offense is not sufficient to prove in and of itself that the defendant was an aider and abetter. A conspiracy is the planning or aiding in the planning of the commission of an offense with one or more other persons, or agreeing with one or more other persons that one or more of them will engage in conduct with a purpose to commit, promote, or facilitate the commission of the specific offense. It is no defense to a charge of complicity that no person with whom the defendant was allegedly in complicity has been convicted as a principal offender. The defendant cannot be found guilty of complicity unless the offense was actually committed. Now,
it almost sounds like he
you
was
have
telling
in
him
your
that no one else was
possession the
convicted.
verdict forms that apply to this indictment. And as you can see, there's one for each count, 1, 2, and 3. So when you get in there, count 1 is obviously on the top, but you see down here, there's some bold highlight here. You set count 1 aside. You can't decide count 1 without first deciding count 2. Okay? So the count 2 is the felonious assault. If you are all able to agree with regard to felonious assault that the state proved each and every element of the offense of felonious assault beyond a reasonable doubt, then you will circle the word guilty on the verdict form, and each of you must sign the verdict form in ink on the corresponding juror line. If you find the state failed to prove any one of the essential elements of felonious assault, then you will circle the word not guilty and again sign the verdict form in ink on the verdict form. Okay? Once you've completed this one, if your verdict is not guilty with regard to count 2, you do not need to go to count 1. Okay? If your verdict is guilty on count 2, you must then go back to count 1 and consider this, the murder charge, and if you find the state proved beyond a reasonable doubt all the essential elements of murder, you'll sign the verdict form, circle guilty and sign the verdict form in ink. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of murder, then you will circle not guilty and again sign in ink. And you will follow the same procedure then for count 3. There's so you could circle guilty if they proved all the elements. If they did not prove any one of the, or they failed to prove any one of the elements, then you will circle not guilty. And again, the verdict form must be signed in ink. Now, the court has instructed you on all the law necessary for your deliberations, and I will now instruct you on how to conduct your deliberations. When you go in the jury room, your first function will be to select one of your number to serve as a foreperson. The person you select to preside over your deliberations does not have greater power, nor does that person's vote have any more importance than the others. He or she serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you an opportunity to express your opinions. One additional duty of the foreperson is to see that the verdict forms are returned to the courtroom after you've reached your verdicts. Your initial conduct upon entering deliberations is a matter of importance. It is not wise to immediately express a determination or to insist on a certain verdict, because if your pride is aroused, you may hesitate to change your position even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinions of other jurors. It may be difficult to remember all the evidence of the law. If you disagree as to the evidence, you should try to resolve the issue based on the collective memories of the jury. If you disagree about the law, refer to the written jury instructions which you will have with you in the jury room. If you're still unable to resolve the issue, the court may, under certain limited circumstances, furnish such information. If you have a question, it should be reduced to writing so there's no misunderstanding as to what you request. Deliver the question to Justin, who will submit it to the court. Do not include the status of your deliberations in any question you might submit. You are not permitted to discuss or consider the subject of punishment.
Everybody's sick.
Your duty is confined to the determination of the guilt or innocence of the defendant. In the event you find the defendant guilty, the duty to determine the punishment is placed by law on the court. Furthermore, in reaching your verdicts in this case, you must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all the disputed questions of fact, to apply the instructions according to your findings, and to render your verdicts accordingly. In fulfilling your duty, your efforts must be to arrive at just verdicts. So consider all the evidence and make your findings with intelligence and impartiality, without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that the case was fairly and impartially tried. If during the course of the trial, the court or anyone on my staff has said or done anything that you consider an indication of the court's views on the facts, you are instructed to disregard it. The judge must be, and I sincerely desire to be, impartial in presiding over this and every other trial. Since you'll have a copy of these instructions with you in the jury room, it's very important to bear in mind that no one part of these instructions is any more important than the other parts. The court cannot embody all law in a single part of these instructions. Only when they are considered as a whole do you have complete instructions of law applicable to this case. Now, there are no cell phones or other electronic devices permitted in the jury room during deliberations. Justin will collect those from you, and they will be secured in my chamber area. Now, jurors selected as alternates are not permitted to participate in jury's deliberations unless one or more of the regular jurors are unable to complete his or her service due to illness or other misfortune. Therefore, I will ask all 12 members of the jury, are you able to proceed to deliberations at this time? All right, Mr. Taylor, Ms. Nolte, while the 12 members of the jury have indicated they are able to proceed to deliberations at this time, Justin is going to get your contact information, and I will contact you if needed. You are at this time still bound by the previous instructions. Do not discuss the case with anyone or permit anyone to discuss it with you. Do not disclose to anyone how you would have voted. If I need you to return, Justin will get in touch with you. If not, once the verdict is read in open court, Mr. Logston, Justin will reach out to you and he'll advise you of the verdict, and at that time you are free to discuss your case, discuss the case and your experience as a juror with anyone you'd like. Okay? So just a few more minutes, and then I think Ms. Burnside wants to see you, right? Well, I'll tell you about that. All right. So the court will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of these records, including the verdict forms, and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdicts are announced in open court, you are not permitted to disclose to anyone else the status of your deliberations or the nature of your verdicts. After your verdicts are returned, you may discuss this case with anyone, but are not required to do so. Whether you discuss this case with the attorneys or anyone else after your discharge is a matter of your own free choice. So go back in the jury room and select a foreperson. Whenever all 12 of you agree on a verdict, you will sign the verdict forms in ink, as I've indicated. Advise Justin by ringing the buzzer in the jury room. You will then be returned to the courtroom for the public announcement of your verdict. A couple of things, counsel, with regard to the physical evidence. I know everything has been photographed. What I'm going to do right now is I'm going to say that the actual evidence, actual physical evidence, we have photographs of everything. I'm not going to send that back unless they specifically requested to be sent. The jury specifically requests that they want to see it. And then I will send back, obviously, the gloves and stuff for the handling of that evidence. Any objection to that?
No, you're just talking about the pants, the sweatshirt, and the blood card, right?
Yes, sir.
Yeah,
We're just running low on gloves.
Okay, so if you guys want to physically see that and not just look at the photograph, we can make that happen, but I want whoever handles that to be wearing the gloves, okay, just like you saw with the witnesses. The other thing is the transcripts of the interviews of the defendant. There were 2 transcripts that were collected by Justin. Again, if you want to see them, send out a note to Justin, and then we'll talk about that separately. All right, at this time, I'm going to send you back to the jury room to begin your deliberations.
Rise.
As soon as they sit down, we'll start the counter. We've got the verdict watch timer, courtesy of Trial TV Live. Thank you for this, by the way, in the bottom corner right now. It's a nice one. They made it themselves just for me. Out go the 12. The alternates are giving their phone numbers to Justin. This is how Justin gets numbers.
You can be seated.
There we go.
All right, Mr. Kniff, anything on behalf of the state?
No, Your Honor.
Mr. Brennan?
No.
All right, Justice got your number, I'm sure.
Yes.
Okay, thank you all.
All right. I want to watch defense here for a minute and just see if a fight breaks out. The defense attorney is doing his best to explain to the defendant that he makes the decisions on how this is argued in closing. The defendant is not liking it at all. His demeanor towards the paper, shoving stuff away. Yeah, I think he's not happy with how things went down. Everyone gets these little bottles of water to sip on. Ooh. Throws away his notes. Gets the old bear hug with the belly chain. And we're off. Wow. All right, we have the opportunity to watch something interesting and probably a little bit lighter than this during deliberation, and it's Judge Simpson. I'll tell you, it's Judge Simpson. Let's see. There we go. We're in black right here, but it's going to be. There we go. It's going to be Judge right here. Back up, back up, back up. Wait for it. This is where we are. Hopefully I can get this to work properly. Let me turn this off so it doesn't interfere. This is a hearing. I think we put it all together. I might have to skip through a little bit. But this is the landlord. This is the landlord, and you're going to recognize the landlord. As we go into verdict watch, let me do this here really quickly. A couple things. Let me first update the pinned message to show that we are in verdict watch. Replace pinned message. I'm going to close out the poll on how long the jury will deliberate. We've got 656 votes. If you want to vote, I'll give you about 10 more seconds to quickly get it in. It's pretty straightforward. The options, which you could select from, were less than an hour, 1 to 3 hours, 3 to 6, or 6 to 8. That basically takes us through, I don't know, the podcast tomorrow night. Let's see, we've got a couple more votes coming in. 679, 682, 684, 686. Maybe at 700, we'll go ahead and shut this down. That gives you about half of you who voted. 692. I know a lot of you are at TVs where it's difficult to vote. There's 700. We're ending the poll. All right, 2 more votes squeezed in at the last minute, and the results were as follows, or 3 votes actually, as follows. How long will the jury deliberate? With 64% of the vote, 1 to 3 hours came back as the winning result. I'll post that in chat for those that need to see it in text format. It's right there with no spaces, because who needs punctuation and all that? All right, let's go ahead and see if we can play this. I've got to play this off the recording, which is currently also recording, so we'll see We'll see if this works. Headed up to Judge Simpson's court now. Let's listen in here. Nope. Stop. You don't have audio. Only I can hear it. Gotta send someone with more experience. There we go.
Time of business before the court drawn here. The Honorable Judge J. Cedric Simpson preside.
May be seated. She's coming in.
Where's our... But who is it? The plaintiff or the defendant? I think it's the defendant.
Court does call the case of Anderson versus Lyman. State your appearance, please.
Lori Anderson. Armani Lyman.
All right, Miss Lyman. When the court says 9 o'clock, I mean 9 o'clock. We're waiting for you to appear at the courthouse.
Okay.
So that won't happen again, correct?
Yes, sir.
All right.
She doesn't
This
seem
is
bothered
date
by
and
it.
time set for trial.
Look at all these
Each side ready
exhibits.
to go to trial.
Yes.
All right. Ms. Anderson, you may proceed.
Should I stand there, sir, or right here?
You can stand
I wanna
wherever
see my
you
opening.
want, that you'll be picked up on a microphone.
Okay. I want to give my opening statement. And then I have one.
Go ahead. Do your opening statement.
Okay. Your Honor.
Ma'am, put the microphone back where it was. We'll pick you up.
Sorry about that.
Don't grab it.
Your Honor, my name is Lori Anderson, and I am the plaintiff and owner of the property at issue. I am here seeking a judgment for $14,606.46, which includes unpaid rent, court costs, unpaid water bill, and damages in the amount of $2,866. Ms. Amani Lyman provided false information on her rental application, including misrepresenting her residency, which influenced my decision to rent my home to her. This is not a typical landlord-tenant dispute. She has a documented history of property damage, unpaid rent, and disruptive behavior, as shown in the exhibits and witness testimony I will present. I want to acknowledge that I appreciate the court's efforts in landlord-tenant cases to maintain tenancy for individuals who might otherwise be homeless. However, this case is different because it involves actual property damage and destruction, not just homelessness. If the court allows Ms. Lyman to remain a tenant, I respectfully request safeguards to protect my home, because this is the only way I will have access to my property. The defendant will not allow me into my home and does not communicate with me outside of the court. While the lease allows me access with a 24-hour notice, Ms. Lyman has denied me entry, making court-ordered inspections necessary. Therefore, I request that the court order monthly inspections at a specific time each month so that these inspections are enforceable and I can return to court if Ms. Lyman fails to comply. Monthly property inspections with Mr. Ivory Clinton present to detect smoking inside the home. Inspections scheduled once per month on a Saturday at a specific time set by the court, preferably 10 or 11 a.m. During inspections, I request permission to take photos of the property condition. I request access to inspect the entire home, including the basement and garage. I will bring an HVAC filter to the inspection and replace it monthly as part of regular maintenance. Inspections will confirm that there are no unauthorized occupants, no further property damage, and no smoking inside the home. I asked the court to instruct Ms. Lyman to allow access to the home for myself and a licensed contractor on October 2nd to repair a crack in the basement, scheduled to start between 8 and 10 a.m. and expected to last several hours. I am also respectfully requesting that the court return 2 zip drives in my possession. I did not present any video evidence in this trial, and these drives contain precious family memories. For this reason, I ask that these videos not be included as evidence. These measures are essential to prevent repetition of past destructive behavior, ensure compliance with lease terms and local laws, and allow me reasonable access to my property. I respectfully ask the court to grant judgment of 46 cents, and if Ms. Lyman remains a tenant, to consider implementing these court-ordered protective measures to safeguard my home. Thank you, Your Honor.
Ms. Lyman, opening statement.
Okay, so I have not been able to peacefully stay in the house. Every time I turn around, she's either down the street or have somebody watching me. So I would really like to be able to enjoy the home, which I haven't. I pay all this money to not be able to enjoy the home. I don't smoke, so there's no smoking happening on the property. There are no damages. And the judgment, that seems like a much, because she's including the rent that I had paid to you guys in escrow in the judgment. Also, I would like an addendum to the lease for my $750 that she said that she legally lied and said that she didn't know that she couldn't put it as non-refundable because somebody else is suing her for the same $750. When I moved in May, I paid $3,300. It should have been prorated because I moved in on May 5th. So that should have been prorated $533.
I'm moving everything around.
Plus the extra $300 that's left over from the deposit. In June, I paid an extra $200. So I ended up paying $3,500. In July and August, I paid the $3,300. The only month I owe is this month. So from
this month being September or October?
Yes, I can pay that tomorrow. The so only every month is $3,300. So with the extra money, me paying the $200, prorated the $530, the extra $300 from the deposit comes up to $1,033. So I figured that I should take that from the rent, and it should be $2,267.
That you owe.
Yes.
We have seen these two square off before. They weren't able to
sort
it out.
Witness. Is that going to be yourself?
The defendant wanted a trial to clear her
Should I
name.
stand there to question the witness? Where does the witness stand there?
It's up to you. Where do you want to stand?
Clinton? Oh, you're my witness.
Let me make everything bigger. I want to be able to see this really well, but we'll shrink down this.
Sir,
one.
please come forward and be sworn.
To make this even bigger because it's cutting off the top. I don't think we have any other displays yet. There we go. It's being sworn in.
State and spell your first and last name for the record.
First name is Ayden, T-O-N.
Your Honor, may I give this to Mr. Clinton to reference?
I don't know what it is.
It's evidence pack number 4 that I've already.
No, that's not the way it's done.
Oh.
Question him and then.
Okay. Mr. Clinton, how long have you known me, the plaintiff, Miss Anderson?
He doesn't know.
Yeah. Can you hear, hon? How he has a hearing trouble.
Get him equipment so he can hear the questions.
I guess reading lips isn't an option right now.
Thank you, Mr. Clinton. Mr. Clinton, how long have you known me, the plaintiff, Miss Anderson?
20 years.
Okay.
20 years.
In your experience, how have you known me to maintain my home, its cleanliness, its floors, the overall condition?
Almost perfect.
Almost perfect? Okay. Do you recall when I was preparing the home for sale in the spring of 2025? Okay. Do you recall the condition of the home when it was listed on the market in April 2025? Looking at the before and after photos in Exhibit 4, Did you ever see a rear screen?
Exhibit 4 hasn't been admitted. I don't know.
I have, yes, sir. I gave them all to the clerk on
It hasn't been admitted, ma'am.
the clerk. I came here on Friday and, Ann, or was it Ann? She said she would give it to you. She gave it, I put it in a packet
But
and
it hasn't been admitted.
how do I admit it?
Ma'am, I can't tell you that.
Okay, so
I don't know who took the photos. I don't know when they were taken. I don't know any of that about these purported photos.
well, how can I get what I dropped off on Friday to you?
Come on, Judge.
I thought you had them.
This is
It had
small
I actually
claims
spent a
court.
lot of money to produce the color prints. It cost me over $20.
Ma'am, whether I have them or not doesn't mean that they've been admitted into trial. Who has to establish those photos and then attempt to try to have questioning regarding those photos.
Okay, I'll do that. Can I admit Exhibit 4 into court?
No, there's no foundation.
Ma'am, I don't know who, there's no testimony as to who took the photos,
The professional
what their photos are.
of my house, the professional photos of my house, and then I took the photos of the damages.
And you need to testify about the photos.
Okay, so what, do you want me to say, go over Exhibit 4 with you?
I just want you to do the trial, but I'm not going to just have you submit things, and I don't know if they've been presented to.
Yeah, no, I sent her all the files, all the files to the defendant.
Okay.
I don't know what those files are.
The exhibits, can we, I spent a lot of money bringing the exhibits to court. And I dropped them off on Friday. She did a stamp, she put a stamp on them to give to you, and she said everything's fine. And so I thought you had the exhibits. I labeled them. I emailed them to you, but also printed them out, but I labeled them exhibits.
Maybe you're not understanding me. You can send to the court whatever you like. It doesn't make them an exhibit in the trial.
So how do I send them to be an exhibit to the trial?
Judge hangs his head. Thinks about early retirement.
I am not here to assist necessarily either side in this trial. Something the court to consider as evidence in the trial, you need to properly admit it.
So how do I properly admit the evidence, sir?
I'm not here as your lawyer, ma'am. I'm here as a judge.
Okay, so you want me to just ask him the questions then? I'll ask him the questions. Do you ever, Mr. Clinton, do you ever remember seeing the rear screen door ripped?
No.
Do you ever remember oil stains in the driveway?
No.
Do you ever remember me mounting a security camera on the south end of the home?
No.
Do you ever recall the master bedroom blinds being broken?
No.
And the front door lock, it was never an automatic door lock. It was always a mechanical door lock, correct?
Yes.
Okay. Can you confirm for the court that the before photos accurately represent the condition of the property before Ms. Lyman took possession, May 5th, 2025?
Where did these photos come from?
They were photos I took when I was, after the home was prepared for sale.
Ma'am, you took the photos.
No, they were taken by a professional because they were actually put in the
Then
MLS.
How's he going to establish that? You need the professional here.
The professional photos were taken, they were put in the MLS, and then I took the damage photos.
What did I just say? Who took the photos?
The professional photos, 2 people.
Oh, goodness.
2 people.
He did not take the photos.
No,
You didn't take these photos.
I took the after photos. The before photos were professional photos for the home to be in the.
My question.
Okay.
The photos that he just talked about, the witness did not take those photos.
No,
You did not take those.
no.
Then where's the testimony about who took the photos?
They were by a professional photographer who takes photos for listing a home in the real estate MLS.
Where are they?
He has a job. I can't afford to pay him to be here. And you don't allow Zoom testimony. So, I mean, I'm doing the best I can, sir. I don't have any money.
I'm going to tell you what. You did not make a request for that Zoom testimony.
I did.
And then
are
you going to keep interrupting me? Because I'm not going to do this all day. The person that took the photos needs to testify as to those photos preliminarily.
To authenticate the source.
I did not know that, sir. But if he could do Zoom.
That's not my issue. I'm telling you. Yes.
I requested Zoom for 4 other witnesses and I was denied because they live out of state.
Because this individual did not consent. You should have at least asked her.
She doesn't talk to me outside of court.
You know what? I am not here to solve the world's problems. Only the issue that's in front of me. Did you make the request of her to have these?
She doesn't, I sent an email.
Did you make the request?
No.
Okay.
But she does not talk to me.
That's an answer to my question.
He can at least attest to the fact that the home was in good shape before she took it over.
I think he already told me.
Okay, that's fine. Mr. Clinton, can you please confirm that the MLS photos are the same photos?
Nope, there are no photos.
That accurately represented the pristine and spotless condition of the property presented to Ms. Lyman?
She's trying.
The home was in pristine condition when it was presented to Ms. Lyman. Okay. Can you confirm that the broken screen door, oil stains, changed front door lock, security camera, broken master bedroom blinds, all occurred after Ms. Lyman took Tennessee?
Yes.
Okay.
Clinton, how often were you at that property?
Before or now?
Before. Well, let's just ask this. How many times have you been to that property?
Or 110?
How many times before Miss Lyman moved in?
How many times? What's it?
Before Miss Lyman moved in.
Oh, about 50 or 60, not more.
Okay, credible witness, 50 or 60
And you've
times.
been out to the property since?
Yes, I have.
For what purpose?
Pick up the mail or
For who?
for
What's your relationship to Miss Anderson?
From the start, well, we've been friends for about 20-some years.
What is the relationship now?
We're still friends.
Just friends?
Just friends.
Go ahead.
What's he insinuating? What do you take for a headache, Judge Simpson? He's already frustrated with this whole case.
Mr. Clinton,
Were you present in the district court on August 15th when Miss Gloria Vanderwell testified in front of Judge Washington regarding 6285 Maplehurst Drive?
It's hearsay.
Hearsay.
Don't answer the question.
Don't answer it. This judge's court stream is sponsored by Excedrin.
Did you see photos showing 2 bathtubs with running water left?
Where? Did he see photos where?
In Exhibit 6 that show the damage she did to Miss Lyman did to the Maplehurst property. They were
to whose property?
To her prior residence. He's seen the damage to her prior residence.
Were you there and saw the damage? I'm not going to allow it.
Even though it was in court that it was presented?
What did I just say?
Okay. Well, I'm learning, sir. Forgive me.
Yeah, there's going to be a test at the end.
Okay.
This is a landlord-tenant issue.
Did you see the final water bill from Ypsilanti Township showing a final water bill for the Maplehurst property of $3,153.69 during Miss Lyman's tenancy at 6285 Maplehurst?
Why am I talking about Maplehurst?
I thought it showed evidence of damage to prior property.
I don't. Have you ever been to Maplehurst, sir? You know the owners of Maplehurst? Do you know anything about that property? Other than that was a bad question. Do you have personal knowledge of anything regarding that Maplehurst property?
Okay, so
I can't testify as to.
Okay, I thought because he was at the court, I thought we could do that. So, okay, there's no further questions for Mr. Clinton.
Any cross-examination, Mr. Lyman? Any questions you have for him? No? Thank you, sir. You may step down.
And he's also Air Force, sir. I'm sorry, you're Army.
Oh, you just insulted him. Army doesn't like being called Air Force. Army looks at Air Force and says, "You've got an easy job." Oh.
Other witnesses.
Miss Lyman?
What?
Lyman, come on up.
Oh, this is good. This will be choice. I'd like to call the defendant as a witness.
You may.
All right, getting all the papers in order. It's a steep ramp.
Okay, this is going to be questions about the lease. To Miss Lyman, which I have a copy here if she needs it, but rent, let's see here. Rent under your lease is due the 4th of each month, correct? Per line item number 41 of the lease.
It has 2 different dates on the lease.
Yeah, but the 4th it doesn't have the 5th. It has the 4th on line 41. I can show you. It doesn't have the 5th. due on the 4th.
Hey guys,
The lease provides only a
enough
3-day
with the
grace
clothing.
period and imposes a $150 late fee
Let's
on the
focus on the
8th
trial.
day, correct?
Don't make the mods have to delete stuff.
It's line number 4 on the lease. Isn't it true that you were late paying rent for July, August, and September? I know, but you were late on those days that you paid the rent. July, in fact, on the ledger, I can give the dates when you turned them in.
What?
Look at the judge.
For July rent, you turned it in August 1st. For August rent, you turned that in September 2nd, and you still haven't turned September rent in. So wouldn't you agree that you've been late on paying rent all 3 months?
Can't hear her. Looked like a sure.
Are you aware that partial rent payments are not accepted under this lease?
On the lease, you said I can deposit a check into.
I'm partial, meaning like you couldn't just pay half of it one day and half of it the other. It all has to be paid at one time. Are you aware that if rent and late fees are not paid, I plan to issue a 7-day notice on the 5th day of the month and file with the court on the 12th going forward, and you will be expected to pay court costs. If I have to bring you to court to get rent, if I file a 7-day notice.
Her mic's not.
Was that a question?
No, I'm making
Is that
her.
a question?
No, I was making her aware of that.
You need to ask her a question.
Okay, are you aware that if rent and late fees are not paid, I plan to issue a 7-day notice on the 5th of the month and file it with the court on the 12th going forward, and you will be expected to pay the court cost.
What's the relevance?
That's just, it's a question just to make.
What's the relevance of that question?
That going forward, if she still remains my tenant, I plan to be on top of it as far as rent. If it's not paid, I will issue a 7-day notice.
What bearing does that have with anything the court has to decide today?
Okay, sorry. Strike that one.
Yep.
Under your lease, only you, the named tenant, are permitted to reside in the home without my written consent, correct? Okay. Who is currently living at 4259 Shandy Court?
Me.
Isn't it true that your uncle and 3 children have been observed living at the property by several neighbors?
No, just because somebody seen people come over doesn't mean it.
Okay. Line items number 19 and 9 and 19 on the lease. Did you change the locks on the home without my written consent?
I told you I was getting ADT.
Without my written consent? Did I write something down? Okay. Are you aware the lease prohibits changing locks without the landlord's permission and expressly allows the landlord entry without notice in emergencies? Do you know that I'm able to go in emergencies? Fire, water? Okay. In an emergency such as water running continuously, fire, or a suspected medical emergency, do you expect me to break the locks to gain entry? Are you aware that my former tenant, Gabriella Anderson, died in Ypsilanti Township?
What's the relevance of that?
I have a history of a tenant dying in my property.
Why do I need to know that?
Because it shows why it's important to have access to a home. As a landlord, if somebody dies, I need to have access to the home.
Does she know that? And if she does, what's the relevance of that in whatever her answer is?
I have a history of
I'm making her aware that the reason why it's important.
This is not a proceeding for you to make her aware of things or what your expectations are.
Okay. I was explaining.
You don't have to answer the question. Go to your next one.
Okay.
He's going to live right here.
Will you allow my licensed contractor, Affordable Dry Basements, to enter on October 2nd to repair the basement crack?
I don't know anything about a licensed contractor.
I sent an email to you at Armani Lyman.
You sent a lot of emails, so I most likely didn't see it, but that's not a good day.
Well, I can.
You also mentioned that they could come in the spring, so.
Yeah, but I don't want it to go through winter. I don't want it to go through winter. The crack is just getting worse, sir. I want to get it done before winter because they can't.
Are you going to ask a question?
I want to ask her when I can schedule Affordable Dry Basements to enter to do the repair in the basement.
This is terrible. In the spring, she says.
Are you aware that it won't pass certification with the crack in the basement? It won't. It's leaking now, sir. So we won't pass the certification.
Why are you talking? You were supposed to be asking questions.
Okay, when will you allow my licensed contractor to repair the crack in the basement? Okay, what month?
Next
so
spring.
Can I ask a question, sir? Of you? Because the crack is getting worse and it's damaging my property. It needs to be repaired. It needs to be repaired.
That's another statement. What's your question?
My question is, I need to, my lease states that I can go in and make repairs with a 24-hour notice. So she's going against my lease by not allowing me to go in.
That's
okay, once again, a statement. You asked, can I ask you a question?
So can I ask the court to enforce my lease? Can I ask the court to enforce my lease?
You can ask the court to do whatever you want. Whether they do it or not becomes a whole other issue.
Even though it's damaging my property. I'm just.
Poor Judge Simpson. Oh man, this is terrible that two people have to go to court to have this conversation.
Well, it was along with that was. I'll go to the next one. Okay. Under the lease, you're responsible for paying all utilities, including water, electric, correct? Okay. Have you paid the water bill for May 5th through August 31st, totaling $1,471.87?
I'm sorry, say that again.
The water bill is in my name. I have worked something out with him already.
Okay, because may I make a comment to the court? If the water bill, okay.
This is testimony.
Okay.
No is the answer. No, you cannot. Mimi Lucy, welcome to the gallery.
Did you pay the DTE bill that was subject to shutoff notice dated on September 17th? Yeah, I got as a landlord, they sent me a shutoff notice.
Oh, for Pete's sakes. Why do I keep getting comments from you and not questions?
Okay, the question was, did you pay the DTE bill that was subject to shutoff?
Answered.
Did you paid it?
No.
Did you pay the electric bill? So the electric's off?
What does that have to do with anything?
Okay. This is the next question. Do you plan to keep the home above 50 degrees this winter as required by the lease? Okay. Are you aware that you will be held liable for any frozen pipe damage beyond your security deposit resulting from temperatures below freezing or winter shutoff? Huh?
I am now.
Thank you.
I am now.
Line number 18 of the lease, repairs due to tenant's negligence. Are you aware that repairs due to your negligence are your responsibility? Will you arrange for the repairs of the torn screen, broken blinds, torn down insulation and oil stains in the driveway by a professional contractor?
I already told you last quarter that the fallen insulation has been put up. The screen is on the checklist. The blinds will get fixed. and the oil stains are barely invisible.
But they're still there. So it will correct.
Is that a question?
Well, so she's.
Or are you just going to argue with her?
Okay. My next question was, if you do not hire your own licensed contractor, will you permit my contractor to complete the repairs and reimburse me? Okay. Are you aware that these repairs must be completed before the next Pittsfield Township rental inspection, May 26, to maintain certification? Thank you.
Yes.
Inspections and smoke damage. Are you aware that smoking is prohibited in the lease?
Yes.
Okay. Will you permit monthly inspections by the landlord with a witness present so landlord can document the condition of the home, including photographs and checking for smoke odor? Are you aware in the lease it says that I am allowed to do inspections with a 24-hour notice? So you don't want to go abide by the lease?
I won't allow you to do it.
That's she doesn't have to answer that.
Okay. Do you understand that if smoke odor is detected and smoke damage is documented, repainting and remediation of the entire home may be required at an estimated cost of approximately $10,000?
What? Really? Where does that come from?
3,000 square feet will cost.
Where does that come from?
I'm just making her aware about smoke damage.
Why?
Okay, sorry. Strike it.
Where
Strike it,
does
sir.
that come from?
I've been quoted $10,000 to paint that house.
By whom?
Contractor, because it's a large house and smoke will sink into the paint.
I don't know anybody named Contractor.
Nicholas Blake, licensed contractor.
Is he here to testify?
No.
Then I don't want any questions about any quote he's given.
Okay.
That's hearsay.
Okay.
Wayne
Sorry,
Hatchell,
sir.
OG,
Yes, sir.
30 months.
Nuisance and children, line item 20.
Nuisance
Are
and
there
children?
3 children residing at the property? Okay. Were those children left unsupervised in the street on or about May 22nd, prompting a CPS call? They were supervised?
Did the neighbors call on your kids?
I don't know if you'll allow this question, but do you understand that the lease prohibits public nuisance and requires you to supervise children? Okay. Cameras and alterations, line number 20 on the lease. Did you install an exterior camera without written consent of the landlord?
Yes, but I did tell you I was being AT. And also the first court date, you said you had no problems with the cameras. So what's the problem?
I didn't authorize installation. I never said I didn't. No.
Period.
I just said.
Yes, you did.
Yes.
The prior court date, I said as a compromise, I would accept it, but I'm just going over what she violated. I thought we
Okay,
wanted.
so she installed cameras
Okay,
and
okay.
installed the security
That's
system.
all I wanted to
All
just
right.
get confirmation. Are you okay? Can I ask this question?
I don't know.
I know I'm upsetting you. I'm sorry, sir.
You're not upsetting me.
I'm not a lawyer.
You're wasting my time,
Okay.
but you're not upsetting.
Okay. Are you aware you will need to refill the holes and repair the siding damage by that occurred when you installed the camera? When you leave, you'll have to do those repairs. Fill in those holes from the camera.
Under the terms of the lease, she has to restore the premises back to a reasonable condition as she got it. I think everybody knows that. Do you understand that, Ms. Lamley?
Yes.
Thank you.
Thank you,
Next
sir.
question.
I think I've already asked about smoking. Okay. And you don't, okay. Are you prohibit smoking? She knows that. Okay. Yard and maintenance.
All right,
Are
here
you
we go.
are you responsible for mowing, trimming hedges, watering plants, and snow removal under the lease? Line item number 24.
Yes.
Okay. Have the hedges been trimmed as required by HOA rules? Do you plan on getting them trimmed so that I don't get a fine from HOA?
Have you gotten a fine?
Not yet, but they've said.
Okay.
Okay. Vehicles.
I'm sorry, this is so funny.
Did you have 2 inoperative and or unregistered vehicles on the property? Okay. Were 2 of those vehicles towed away? Okay. Did those vehicles cause oil stains in the driveway?
Welcome, Muffin Tops. Hello, Broken
Do you
Baker.
plan on hiring a professional contractor to remove these oil stains?
The oil stains are already there.
Subletting and insurance. Are you currently living at the home by yourself? You already answered that. Okay. Have you sublet any part of the home to another person? Are you aware that subletting the home is prohibited without written consent? Do you currently maintain renter's insurance as required by the lease? Okay. On May 5th, 2025, rental application, you listed your current address as 9090 Arlington Drive, correct? Okay. At the time, you were actually residing at 6285 Maplehurst. Proceedings were pending, correct? You were residing somewhere else that you didn't put on the application as your current address. No, it said current. Because you were being evicted, I based my decision to rent to you based on 6285 Maplehurst started eviction proceedings in January of 25. I was not made aware of that when I rented my home to you. Did you disclose that the pending eviction of your true address to me before moving in? Did you disclose that address to me before moving?
Was she required to?
Yes, the application said, where's your current residence? So I could follow up with the landlord of that residence.
That was not your question.
You
asked her whether or not she disclosed an eviction.
Yeah.
On the application, does it indicate, have you been evicted?
Yes, there's a section in there, any prior evictions on the application.
All right. At the point in time she applies, has she been evicted?
There were eviction proceedings.
Is that what the question asks?
No, it says, have you been evicted?
Thank you.
Oh, sir.
So that case had not concluded. Is that correct?
That's correct.
Okay. Then if you're saying that she misled you, your question is bad.
A bad question.
Well, but
as it has been all this morning.
Okay, but she didn't disclose where her
You want to
address
argue
was.
with me?
No, honey. I'm sorry.
She doesn't have to answer that question. No, actually, she answered the question.
Okay.
Don't honey the judge.
Are you aware your lease states that breach of the lease gives the landlord the right to repossession? Line item number 32. Are you willing to remedy the lease violations or return the property to me? Okay. Do you understand line item number 36 on the lease? Only written agreements signed by both parties are enforceable under the lease. So verbal doesn't mean anything. It's only written.
So all this stuff you're saying, will you agree to this? That doesn't matter. Even if she's under oath.
Not
enforceable.
Okay.
All right. Are we done?
Okay. This is questions with regard to the lease application. Miss Lyman, are you aware that the phone number you listed on the lease application, 734-460?
Wow, just caught that.
Is that correct?
I listed that number back in 2023.
No, on the application you just gave me, in 2025, you have that number on the application. Okay. Are you aware that according to reverse lookup, that number is this number is registered to you, but I've never received a response when texting or calling you on this number?
So, okay. If she says yes to that, what's that mean to me?
Okay. Okay. Scratch that one. Okay.
Yeah.
Isn't it true that the only way I have been able to communicate with you is through your mother, Joanna Lyman, at 735?
No, you don't know. That's not.
Okay. Please confirm, do you regularly monitor or respond to your phone you listed on your application? Well, I guess that would be no because you.
Well, are you going to answer it or are you going to let her
Okay.
answer?
Okay, sir. Sorry.
It's fine. You just send a lot of messages.
Okay, so the number of 734-465-8.
Holy cow, man.
Okay. Okay.
I've got to be hot with the editing button.
On your application, you listed your current address as 9090 Arlington Drive. Current address. Okay. Isn't it true that at the time you completed your application, you were not living at 9090 Arlington Drive, but 6285 Maple? But you were living at 60. Okay.
Oh my goodness.
Isn't it also true that you were being evicted from Maplehurst property owned by Miss Gloria Vanderwell, your former landlord? She's the owner of the property. Greg is her husband. Okay. Yeah, that was the person that was at the prior trial. Yeah.
Look at the judge.
Okay.
Hitting his glasses.
On your application, you stated that you were renting a room from your parents, Desmond Jones, at $500 a month, correct? Well, it's on the application. It says Desmond Jones, and you told me you were living with your parents.
I said living with family.
Okay. But on the application, it says you were living at 9090 Arlington, $500 a month to your family. That's what the application says.
Yes.
Okay. You also wrote that the reason you wanted to rent my home was to have a place of my own, correct? Okay. In reality, weren't you leasing your own home at 6280 at the time and facing eviction for non-payment of rent and property damage?
What does Maplehurst have to do with Cheney?
The question is because you falsified the application, so you committed.
That's a conclusion.
If she said her current address was 99.
Conclusion. Get to your next question.
Okay. Do you admit that the address you provided on your application was false? Do you understand that providing false information on rental application is considered fraud?
Well, don't answer that. That's a legal conclusion you're asking.
I've been doing my Google searches, sir, and this is what I come up.
Then bring Google.
Is she typing all this, sir?
Every word.
Was I given?
You know what?
I'm just asking.
You know what? You know what? I'll tell you what. I'm taking a break. You get your questions in order, and you understand how to address this court. Am I clear?
Yes, sir.
Have a seat. You may step down. Court is.
All right.
And there he goes. All right. So while the judge is out, do we have a hot mic? No, we're on fully private. Okay. We're not counting this in the private counter. We're going to fast forward a little bit and see if, let's see what happens right here. I think they come back in here. Just 1 second. 5, 4, 3, 2, 1, 0. Here we go. We need to go full screen on this for in a second. Okay, that's what we've got right now. All right. Defendant's back in. Plaintiff's there in the back by the neighbor, who was not very helpful because he doesn't actually have first-hand knowledge about almost anything. We're returning to our positions. She helps hold the door open. Oh, that's neighborly. Don't let the gates, hitch on the way in, right? Let's see if we can fast forward just a teensy bit. Okay. It's right about here, but not sure why we had a jump. Did I edit this wrong? They don't. If they could only just talk to each other right here, they could resolve all these issues. But no, that's not going to happen. Okay, now we're back in session.
You may be seated. Ms. Lyman, why don't you come on back up?
Okay. We're back. Ms. Lyman's going to come back up. We're going to continue some questioning. The judge has yelled into his pillow. Feels a little bit better.
May continue your questioning.
Thank you, sir.
Funny thing is the landlord wants to keep this tenant. She's like, it's a ton of rent. It's $3,000 a month in rent.
Do you admit that the address you provided on your application was false as your current residence?
No.
Do you understand that providing false information on rental application is considered fraud?
You already asked that question.
Oh, I'm sorry, sir. I
Strike it.
forgot where I was. Was I given truthful information to conduct my due diligence as a landlord, or did I base my decision to rent you on falsified information?
She's not going to be able to answer that. That's in your mind.
Okay. Sorry, sir. Your driver's license issued in 24 showed 9090 Arlington Drive as your address, correct? You were actually living at 99 when your driver's license was issued, or were you living at 6285? Do you acknowledge that listing 9090 Arlington, your address, misled me about your true living situation at the time? Do you understand that I relied on information you provided in your application when deciding to rent to you? Are you aware that had I known about your prior rental history of fraud, non-payment of rent, and property damage at Maplehurst, I would not have rented my home to you?
She can't answer that. That's you.
It's in your head.
Okay. Would you agree that my decision to rent to you was based on information you provided that was not?
She can't answer that. That's you.
Okay.
As to the form of your question.
Ms. Lyman, are you aware that Mr. Diop Dimba has owned and lived in 9090 Arlington, Superior Township, since December 21? You and your family rented the property from the previous owner prior to December 21, correct?
Rented what property?
9090 Arlington.
It's a prior address. She doesn't live there. So
All right, you can answer it for what it's worth.
No, you didn't rent it? After Mr. Demba purchased it, you did not live there, true? Okay. Your driver's license lists 9090 Township as your address, correct?
You already asked and answered. Don't answer.
That driver's license was issued July 16th, 2024. You were living at 6280 Lanny Township, correct?
Don't answer that. Asked and answered.
Did you have permission from Mr. Demba to use Arlington Drive on your driver's license or rental application?
Keep asking about him. I don't know who that is.
Okay.
Keep asking. I don't know who that is.
Did you use Arlington Drive to mislead me, the landlord, into renting my property to you?
Asked for previous address. I gave you the previous address. I don't know.
I asked for a current address on the application, not a previous.
More questions about the neighborhood or 99.
Did you knowingly provide false information to gain advantage in renting my home? Okay. Are you aware that using someone else's address without permission is considered fraud under Michigan law?
Legal no, conclusion. She can't answer that. You're asking for a legal conclusion.
Did you understand that this could lead to criminal or civil penalties?
She can't answer that.
Do you admit your use of Arlington Drive was unauthorized? Okay. So, Ms. Lyman, even though you were living at 6285 Maplehurst in Ypsilanti Township, your driver's license issued July 16, 20. Application listed 9090 without permission to mislead me into renting my home, correct?
These are all prior addresses. I don't need to edit them out, but it helps if I do.
Ms. Lyman, Ms. Lyman, can you explain why the following damages are present after you took occupancy? Broken master bedroom blinds, oil stains in driveway, broken rear screen door. We already know about changed front door locks and mounted exterior camera, but what about the broken master bedroom blinds, oil stains in the driveway, and broken rear screen door?
The rear screen is on the checklist. So, oil stains in the driveway.
Okay, so you're going to replace the blinds eventually, or? Okay, thank you. Are you aware that under paragraph 18 of your lease agreement, you were responsible for these repairs? Okay, I just,
She sounds like a broken record. This is not a good look from Judge Simpson. You don't want to get this look from him if you're in his court.
Ms. Lyman, your tenancy began on May 5th, 2025, correct? Are you aware that the property had a valid certificate of occupancy and issued May 2025 before you moved in? Do you understand that a certificate of compliance means the property passed all required inspections and met township standards at that time? Are you aware that of the email from Mr. Frank Daniels, which I forwarded to you, Ypsilanti Township Housing Inspector, stating that the torn screen and torn insulation now present?
Ypsilanti Township?
Pittsfield, I'm sorry, sir, Pittsfield Township. Torn screen and torn insulation would not have passed inspection May 2025. So based on the inspector's statements, those items were not present at the time of his certification, correct?
Yeah, what you know.
So those damages occurred after you moved in. The screen door was not on what checklist? The screen door was not, that screen door was not like that. That Mr. Daniels.
Is that a question?
Yeah,
no.
The question was damages occurred after you moved in. Because
that's a statement.
Mr. Daniels states that the screen door in that condition would not have passed inspection.
What's the question?
Proof of condition that we got.
What's the question?
The question is,
you keep making statements.
Therefore, the damage occurred after you moved in, correct? Because Mr. Daniels inspected the property and it passed. And she moved in, and he said it would not pass
He just hit his head on the desk.
with the screen door.
So what's the question?
Just her acknowledging that she'll repair it in due time.
She already said that
Okay.
she was going to do that.
'Cause we
I
won't-
mean, and if she doesn't, that's part of the reason you have a security deposit.
I know, but the problem is when we get the inspection next year, it won't pass with these items.
Okay, and then I don't know how you see into the future that way.
Okay, I'm just trying to cover all my bases, sir. Sorry.
I just want to say that I never said that I would hear the screen door because it was on the checklist.
The screen door was
I
not on the
heard
check.
you.
So you're not going to repair the screen?
I'm off the screen door. If she says it's on the checklist and you're saying it's not on the checklist and there's damage to that, that's going to have to be dealt with at some other point. It's not to be dealt with here. She's answered the question about the screen door. Go on.
Okay. You signed a lease that includes section 18, which states that tenant is responsible for damages and repairs caused by tenant during your tenancy, correct?
That's asked and answered.
Okay. Are you aware that the torn insulation violates property maintenance code section 102.2?
I swear I've heard this like 6 times.
Are you aware that the torn screen violates property maintenance code section 304.14?
It's the PI code 3.14.
Do you understand that the property cannot pass inspection next year, May 26, unless these repairs are made?
It's irrelevant. Irrelevant. Next question.
Okay. Do you want to maintain your tenancy at this property? Okay. Are you aware that to maintain tenancy, the property must be recertified May 26 and these repairs are required to pass?
Go ahead and answer that if you can. It's not going to matter to me.
Okay. So, Ms. Lyman, to summarize, the property passed inspection and received a certificate of compliance May 25. You moved in on May 5th, 25, and the torn screen insulation would not have passed inspection. They occurred after you moved in. They violate township codes, and under section 18 of your lease, you are
Is
responsible.
there a question?
Nope.
Okay, Ms. Lyman,
The judge could be doing a lot of things he'd rather do than this right now.
okay, accountability and lease compliance. Ms. Lyman, do you see that as a tenant, you are responsible for ensuring that all occupants, including guests or family members, comply with lease terms and local laws? Do you see that having unlisted occupants and unsupervised children could put the property of the residents in your tenancy at risk?
How?
Unsupervised children?
Yes.
They were running in the street, sir, and the neighbors complained that they almost hit one.
Then how does that put her tenancy at risk?
Oh, I thought it.
You have children? Okay, so hold on. So I don't even understand where that question might even go, given the greatest benefit to the question.
There was a police report that kids were running around unsupervised and CPS got involved.
Okay.
And I provided that to the court.
And so what does it matter if they're not her kids?
Okay, I'm not a lawyer. I'm trying my best, sir.
I can see that you're not a lawyer.
Forgive me.
I gotta ask you some questions. I don't know how you're attempting to try to hold her responsible for kids that aren't hers, if you haven't even established her kids that are a guest of hers.
Okay, okay. Appreciate that, sir.
Okay, that whole file's out of the way.
Okay,
next
Ms.
issue.
Lyman, do you, I sent you a copy of the HOA vehicle policy for the neighborhood.
Oh, good.
Are you aware that the policy states that unregistered or inoperative vehicles are not permitted on the property? No. I'm just.
Are there vehicles on the property?
No. This is.
Then why?
Okay.
Why are you dealing with this?
Okay.
That's that one's. Let's move that over as well.
Okay.
Anything left?
And you said it's hearsay about Maplehurst. So this next exhibit was all about Maplehurst. So you're saying that that's hearsay?
Ma'am, I don't even know what you're talking about.
Her prior residence. That was this next section. The damages to her prior residence. And that's
the damages to her prior residence. I don't know why that would be relevant to me. And I don't also understand that. I don't even understand how you're getting that in.
well, I just thought showing a history of destruction is relevant to my house and me being concerned. It shows why I'm concerned about my property. I'm not just concerned for just to be concerned. I have a reason to be concerned about my property. That's all. I'm just, this is my $570,000 baby. I care about my home.
$570,000.
So section 6 is off there.
Yep, we'll just set that aside. She's looking at pictures. She's getting ready for her case. This is funny.
So that's it for questions. I wanted to go over section. I had something for the court, but I'm done with asking questions of Ms. Lyman.
All right. Ms. Lyman, you'll have an opportunity to testify. You may step down. Any other witnesses for the plaintiff?
No, sir.
All right, here's what I'm going to do. Ms. Lyman, prior to your opening your case, should you decide to give one, court's going to stand in recess and it will go. Go ahead, you can go.
Do I sit down, sir?
Pardon?
Do I sit down, sir?
You can sit down if you want.
Okay, well, you're the boss.
I know. You ought to remember that.
I was going to wear a hat. I love Judge Simpson.
What? He doesn't even know.
Here's what I'm going to do.
He's going to reply.
I'm going to break for lunch. It's a little bit early, but I thought we might get somewhere this morning. I'm going to break for lunch. We'll reconvene at 1 o'clock.
We're going to fast.
And then if there are no other witnesses for the plaintiff, then we'll go to defense's case at that point in time. All right? 1 o'clock. Not 1:30. 1 o'clock. Okay? Thank you. Court stands in recess.
All right, so off goes the judge.
Up to stand, be sworn.
We're back. Lunch is over. Switch the tables.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony?
The landlord
State your first and last name for the record, please.
Go ahead.
Is it true that you told me Ivory Clinton was your domestic partner? Is it true that you have been showing outsiders pictures of me containing my personal information?
No.
Is it true that you gave me verbal consent that I could get my $750 decline deposit back?
If the house is in the same condition as I do.
Is it true that a prior tenant is also suing you for their $750 decline deposit?
No.
May I get a written addendum of me getting my $750 decline deposit back?
No.
Why not?
Because it depends on if you leave it in the same condition as I got it. If it's stick and stand claim, that's going to depend on how.
You said verbal consent doesn't matter, so I'm asking you, can I get written?
Deposit back if it's not clean. If it's clean, then I'll give it back. It has to be clean.
May you write that I can get my $750 deposit back?
If it's kept clean. Same condition, like floors are clean,
Can I just stop here? The $750 is listed as non-refundable, but you are indicating that it's refundable provided the conditions are met.
To my satisfaction.
Well, ma'am, is that what you're saying?
No.
That is not what you're saying? You're saying that it's still non-refundable?
It is dependent upon conditions of the reason.
Understand what I'm saying. At this point,
If I don't have to hire someone.
you want to know what? You interrupt me, we're going to have a real issue.
Sorry.
There was a notion that the 750 was non-refundable, meaning it didn't matter what Ms. Lyman did. What I'm hearing at this point is that it is refundable. The conditions of that refund will wait to some other point in time, and there might be further litigation regarding that.
Yes, sir.
Is that what I'm hearing?
Yep.
Ms. Anderson?
That it's conditional return
I don't know what that means.
if it's left clean, like the toilets are clean, the bathroom.
Okay, understand something, what I'm saying. The cleaning deposit, if it is non-refundable, which would create some other problems, that means irrespective of what it looks like or what Ms. Lyman does, the 750 does not come back. A refundable cleaning deposit means that I have the 750 and that 750 would be returned provided it is left in a clean condition.
The same condition I gave her, meaning I don't have to hire someone.
Ma'am, I'm telling you what. Your interpretation of landlord-tenant law is going to get you in trouble.
Yep.
I think I've got it, Ms. Lyman. You can go on to your next subject matter.
Okay. Is it true that I have not been able to enjoy my home due to you continuously harassing me?
No.
Is it true that you have the neighbors watching my home?
No.
Is that not what you stated inside text messages?
No.
Okay.
Can I refresh your recollection?
You did not say
Hey, what's
that
going on
you
down there?
had people watching your home,
Defense attorney.
Ms. Anderson.
And did I say people watching the home?
Let me just ask this. Did you tell Ms. Lyman that you had people watching the house?
Ever since the incident with,
Not my question. It's not a qualified answer. That's a yes or a no.
yes,
Then why did you under oath just tell her no?
well, they're currently not watching the house.
Well, that's not what she asked you. Why are you changing the answer that you just gave to Ms. Lyman?
What's happening? What's happening?
No, I want to know why you changed it. She asked you the question. You told her no. I asked you the question. You told me yes, you said it.
People were looking at, okay, I guess right now they're not looking, before they were.
Oh, that is not what she asked. Go ahead, Ms. Lemon.
Okay. Is it true that you have parked down the street stalking the house
In the past, yeah, when I was trying to get evidence for the court.
and popping up on places where I have been?
Okay, we're gonna pause this.
Is it true
gripping-
not only do you talk about me through text messages, you CC other people in my email that has nothing to do with them tarnishing my name?
We're gonna pause right there. Don't go any further. We're going to jump here. We don't know what's happening. We won't know until the judge announces it, and so hold tight. We also are not going to start before defense gets here, or excuse me, prosecution gets here. Wow, bailiff in the back has 3 spare magazines. He's got one in the in the pew-pew, and then 3 more, probably 10 to 15 in each one. The guy's loaded for bear. He's ready to go. That's a lot of spare mags. Let's see if there's a question here. It could be the jury asking to see the transcript. It could be something, jury asking for better food. Where's the menu? Lunch hasn't arrived. We thought we'd probably get fed here. Judge is in a good mood. Wait for it. Wait for it. It's a dinner order. It's 3:30. Our deliberation timer, if you want to take a quick peek, is at 1 hour and 20 minutes. That would mean that if this is a verdict, it would be about 1 hour and 15. See if we can get some audio. And I'm gonna need to talk fast. That's Andrew. Andrew's trying to get a hold of somebody, not able to do it. Bailiff takes a little rest on the bar, the wall there. A couple other bailiffs come in. That indicative of possible verdict. Get some tissues ready. You're going to need them, says his lawyer. Possible verdict. Judge checking the scores on ESPN, Sports Central. Looks like this team doing okay. Doing okay. Little tuck in on the shirt from the bailiff, looking good. You'll pass inspection. 3 bailiffs. I think we're going with verdict. Do we call it? Do we call it? Do we do it? They did leave the chains on. Wait, says Katrina Bunny. Wait. No, not yet. 4 deputies equals verdict. No prosecution yet. There's our court clerk. Hey, Andrew. Welcome. I agree. Those aren't bailiffs. I'd say verdict. I think they're bailiffs. We won't know until the judge's mic goes hot and he informs us. And then we have just a very limited time before the jury comes in. Here comes prosecution. Here comes the team. Waiting for the judge to turn on the mic. 3, 2, 1. Judge, we're ready. Let's do this. Still a little disagreement on the defense counsel there. Here's your phone. Everyone's ready. Trying to read lips. Andrew takes this. Whoa, what's Andrew doing? He's just chilling in the witness chair? Nobody's happy. A lot of shaking of heads. The judge isn't happy. He throws up his hands. Where's the family? They're asking for the family. The family's not there. Victim's family. Bring him in, he says. Judge says, bring him in. I read those lips. Bring him in. We're not waiting for the victim's family. I think it is. I think it is. I don't know. I don't think it's a verdict. Maybe they don't. We've got 4 bailiffs there. We're not sure. This is just a trial run to see if the verdict music fits between when the judge says we have a verdict and bring the jury. And it does fit. It does fit. All rise, jury walking in. Let's turn this down just for a minute. Might be a question. Might be a question. Defense looking for eye contact.
Thank you. Please be seated. Mr. Bramlage, I see you're holding the forms. Are you the foreperson of the jury?
We have a verdict.
Can you tell me, has the jury reached a verdict? Yes, we have. Would you please hand the verdict forms to Mr. Loxton?
I didn't get to summarize it. We have a verdict. 1 hour and 50 minutes of deliberation time. The jury has determined if James Ogletree is guilty of killing Marquise Wetherington, a fellow inmate at prison.
The matter of the State of Ohio versus James Ogletree. As to count 1, we, the jury, being duly impaneled, sworn or affirmed, find the defendant James Ogletree guilty of murder as he stands charged in the indictment. This verdict form is signed by all 12 members of the jury. As to count 2, we, the jury, being duly impaneled, sworn or affirmed, find the defendant James Ogletree guilty of felonious assault as he stands charged in the indictment. This verdict form is signed by all 12 members of the jury. And as to count 3, we, the jury, being duly impaneled, sworn or affirmed, find the defendant James Ogletree guilty of aggravated robbery as he stands charged in the indictment. This verdict form is signed by all 12 members of the jury. Does the state wish to have the jury polled?
No, Your Honor.
Does the defense wish to have the jury polled?
No, Your Honor.
No.
All right, ladies and gentlemen, that concludes your service. You have the court's thanks. I think Ms. Burnside wanted to talk to you for a little bit. Maybe the attorneys want to talk to you. So if you will return to the jury room, Mr. Logston will return your electronic devices to you, and I will be with you very shortly, okay?
He's mad, but he doesn't look surprised.
Thank you.
Sure doesn't look surprised. Not shocked at it in the slightest.
You can be seated. All right, we'll set this up for sentencing.
Your Honor, there is the matter of the RVO, the repeat violent offender specification, that I know is for the court.
Right. That's why I was going to set it for sentencing. We have those prior convictions, so I'll let Mr. Brenner set it within the next few days or week, no farther out than a week. That should be enough time. Is the victim's family from out of town?
Yes, Your Honor.
All right, why don't we try to get it set still sometime this week, Mr. Brenner?
Your Honor, I have a hearing scheduled on your calendar for Friday morning.
Okay, you want to set Friday morning, so?
Your Honor, I think they have a hotel tonight, but then I don't know that they can, what's today?
Wednesday.
Today's the 1st. Wednesday the 1st.
Do you think? We'll figure it out. You want to get it this week, though, yeah?
I think that'd be more convenient, wouldn't it, for everybody?
Get her done, says the judge.
Already planning to be here in town for tomorrow, if that's helpful.
I can be available tomorrow.
All right, let's see if we can schedule it for tomorrow.
I'll talk to staff. Yep.
All right, very good. Thank you all.
Thank you, Judge.
Defendant's not happy about this. He thought he could get off from this one, but I guess I'll have to say the blood probably sealed it, and the fact that it happened on video. That could be enough in the minds of the juries to say, you know, we know something bad happened. He's smiling. He's just chillaxing. Makes me a little more confident with the jury's verdict at this point. Wow. The family wasn't there. The judge did not wait for the family to show up. They missed the moment where they found out that there was going to be someone held accountable for their brother, for their son's murder. What was that? 4 out of 4? Is that his record? I don't know what that was for. That was a little signal. Jury was dialed in. It was quick, very quick. Hour and 15 minutes of deliberation time. Now it's time for jokes. Everybody's friends. We all get along. Wow. Jury did amazing. Cummings is still in prison. His co-defendant, who was in that room with him the time when the blood incident occurred, whatever that was, his co-defendant was found not guilty. Did not get any additional time, and he was found guilty. Interesting, because it sure looked like the co-defendant might have been more instrumental in planning and carrying out this, although he didn't get any blood on him. But it's interesting. I've got to figure out how they think that occurred without any injuries. But jury had great questions. Fantastic jury on this one. Sorry, now I have the hiccups. Co-defendant wasn't covered in blood on CCTV. That was that's when they say caught you red-handed. I think that's what they're talking about. All those questions the jury asked. We stream the sentencing. We'll watch for it. Well, that was fun. Can we have the entire jury on your show? We love them. Probably not. I've never reached out to a juror before. I've had jurors reach out to me, but I've never reached out to a juror, and I don't think we've ever had a juror on the show. Period. I don't think so. Was Cummings' trial streamed? Yes, it was, I believe. Let's go and let's bail on this court and head back to where we were in Ypsilanti.
All the witnesses who have told me things, I try to include them. But I'm not trying to change.
What does that mean? What do you mean there are emails?
Like she emails a whole lot of stuff and put people from the neighborhood that I don't even know or people that I never met in the emails of her saying certain stuff to me and falsified information on me.
Slander? Libel?
Miss Anderson, do you do that?
I've heard emails, including the neighbor's yes.
She does?
About Miss Lyman?
Yes.
Why?
Because they're telling me they're concerned about kids running on them.
And was it only about the kids?
No, in email she has stated false things like crack pipes, that there's a rapist in the home, different stuff like that.
Hold it. And I'm just going to remind you, you're under oath, under penalty of perjury. Did you say things that directly indicate that there may be drug use and or a rapist in the home?
Yes, because when I looked up this Mr. Lyman, he had criminal history.
You emailed Miss Lyman's
neighbors,
which are her neighbors, while she's renting,
They were saying,
indicating that there was drug use, particularly hard drug use, like crack, and that there was a rapist at the home?
I said a potential somebody with a criminal history.
Did you say potential?
Yes, I did. I said, if this Mr. Lyman, who was named Augustus Lyman, lives there, he has an extensive criminal history.
Why?
Because I wanted to alert the neighbors. So
Alert them of what?
I don't know who's living there. I didn't do a criminal background check on this person, and so I had to look it up online through ICANN.
This is so bad.
And this particular uncle had a rap sheet. And I
was the address listed, Miss Lyman's address?
No, the uncle, but I did it.
Fine, but was the address of that individual list, was it Miss Lyman's address?
I was told that the uncle.
I don't care what you were told. Was the address, when you looked it up, was that Miss Lyman's address?
I don't know what Miss Lyman's address, it wasn't under Miss Lyman's address, it was at the uncle. I looked up the uncle.
I just want to state that is not my uncle.
When you look up, if it is a sex offender, you will have an address that they are registered to.
It wasn't.
Was he registered to that address?
It didn't have sex offender. It said attempted sexual assault under Augustus Lyman. He had that when I looked him up online. He had a big. Oh
my God.
So.
And you sent that to Miss Lyman's neighbors?
Yes. Because they were concerned who was living there and what's going on.
Court's in recess.
All right.
Recording's done.
Holy cow, we have bigger issues here. Let's see how long the judge stays out. A few. Let's see. This judge steps out for just a minute. Hang on. I need to turn this other one on.
Yes. Because they were concerned who was living there and what's going on.
Court's in recess. They get up and walk out. Let me turn the sound off just for a minute so I can scroll a little slower. So everyone goes back. We sit for just a minute or two. I'm scrolling ahead. We're in recess. Still. Long break. Okay, here we go. We're coming back. We're back.
All right, good. Yeah, we're good. Can you find them, please?
Can you find them? We're missing both the plaintiff and the defendant. Mr. Allen goes out to herd cats. This is getting spicy.
Good.
Now I know why the renter said she wanted to go to trial. She didn't want to reach an agreement. She wanted to go to trial so she could clear her name, was what she said. So she could clear her name, and now it's becoming blatantly clear why.
We're back on the record in the case of Anderson versus Lyman. Ms. Lyman, you may continue.
Is it true that you gave me verbal consent to get ADT?
I gave verbal consent, yes, but that was not for cameras. Now for recorders, no locks changed. That was for sensors in the inside. I was not told about door locks or cameras.
Is it true when we first started going to court that June rent was already paid?
June rent was paid late, but it was paid, yes.
Is it true that you have called the Pittsfield Township Police Department on multiple occasions presenting falsified information?
Oh.
When I can't get a hold of you and I'm concerned about what's going on, I call them because you don't respond.
So are you saying
what?
What?
You call her, she doesn't respond,
and so
you call the police.
by text, just wanting to see my property and not having any responsibilities. Because I, again, I'm not able to see.
You call her, text her, whatever. You don't get a response, whether she's choosing to or not, and you call the police. And what do the police say? I mean, what do you say to the police?
Make sure she's still alive.
Oh, for Pete's sakes.
I just want to state, not only is it a wellness check, when the police come, they had told me she must have something against you. They don't be feeling like coming out because it's always something, and they say it comes from her.
Go ahead.
That was a statement.
Is it true on multiple occasions I asked you to stop sharing my personal information?
You said don't include other people in the emails, yeah.
Is it true on multiple occasions that I asked you to stop sharing my personal information?
Yeah.
Then why do you still do it?
I stopped including everyone in the emails. You told me to not include your standard well. Only if it's involved with me. Like if it involves Maplehurst, I still include this thing. If it doesn't involve him,
I think some people shouldn't be renters, and some people shouldn't be landlords.
Is it true that you told me that you have a multiple personality disorder along with other mental issues?
Let's strike that. I don't. You just.
I was asking.
Just
is that the
stop. Stop. She doesn't have to answer that question. Go to your next question.
Is it true that I treat you with respect and all you do is disrespect me? Do you feel you know personal boundaries?
The judge laughs.
you don't respond to my text, so I don't know how to get hold of you.
You don't respond to my text.
Is it true that you're going through financial hardship?
Yes.
Is it true that you have stated in an email that you will pay the water bill and that I could reimburse you?
That's why I want to get a judgment so that I can pay water bill and you on hospital status. I won't pay it if I can get a judgment for you to reimburse me.
But if you're going through financial hardship, how would you pay the water bill?
Someone has to pay it. I'll get a loan. I have, I'll borrow it. Someone has to pay it. Because otherwise, if it doesn't get paid, it goes on the taxes.
Go to your next question.
Is it true when we met back in May of 2025, you pretended that you were a realtor and not the owner yourself?
No.
Whoa.
Is it true that you stated that the crack could be fixed in spring of 2026?
It can be fixed, yes, it can be fixed in the spring.
Okay. Is it true in May of 2025, I paid $3,300?
You paid May rent, yes.
Is it true that I paid $3,300 in June?
Yes, you paid it.
Is it true that July and August rent is in escrow?
Yes, late, they're in escrow, all late.
When I paid the rent back in May of 2025, is it true that it should have been prorated $553
No,
since
you don't have to start on the first of the month.
since I moved in after
Let
the
her
first?
finish the question before you respond.
No, our tenancy starts on May 5th
She
through May
continues.
4th of 27, which means that your rent is due on the 4th. Your rent is due on the 4th, and your tenancy, that's how we did it on the lease. You don't have to start on the first day of the month.
I was asking, since it was after the first, should it have been prorated
No,
$553?
We're starting on, I said.
Your answer to that is no. Go ahead, ma'am.
Do you know Marcus Escano?
That's irrelevant,
You'll answer the question.
unfortunately.
Is it true that he is suing you for $750?
Ma'am, you are not going to interrupt the question. Go ahead and ask your question.
Is it true that he is suing you for $750, which is the same amount as the cleaning fee?
You can answer the question. You don't know? You don't know? Is that your answer to the court? Because I'm directing you to answer the question.
I have not been in touch with Mr. Lozano.
That's not the question. Is he suing you for the $750?
I'm not aware of that, but
Go ahead, Ms. Lemon.
Whoa.
Are you aware of the bailiff that came on behalf of Marcus Escano to the property and was on the phone with you?
somebody called me and I didn't know who they were, so I told them.
Relevance.
Let me ask this. This Marcus Toscano and the $750, has he sued you?
No.
Was there somebody appearing at the property regarding a dispute between the two?
I wasn't at the property. So someone called me,
Okay,
but I don't.
all right. Somebody, you know what? You can play your word games or not. Look it up.
Can I spell?
Do you know how to spell Mr. Toscano?
His name is Lacano.
Okay. Go on with your next question while we look at it.
They're checking the books.
Is it true that you made Ivory Clinton block my driveway on July 1st of 2025? That was during an inspection. What if I told you I have video evidence of you having him do that? Okay.
You have video of him blocking the driveway?
She blocked the driveway on July 21st during the inspection, and it was on video. I can see if I can find the video where she told him to pull up and block the driveway.
Hold on. You think you have video of that?
Yes.
All right. Go ahead. Next question.
Yeah.
Oh my goodness.
Is it true that you told me that the $600 custom blinds are not custom and that I can just take them down and present them at Lowe's?
No, they are custom, but you can look at the manufacturer on the blinds and get the same manufactured blinds so that they match. They are custom.
What if I told you the last time we were here in the back room that I have evidence of you stating that I can just take them to Lowe's and that they're not custom?
They need to be the same one. They gotta match. If it's just a generic brand, it doesn't match. That's right. They have to match.
That is not what I asked. I said, what if I told you that I have evidence of us in the back room and you stating that I can just take them down and show them to Lowe's?
Yes, same time.
Custom and Lowe's is
it true that not only have you been harassing me, you have had another attorney harassing me whose name is James Fink?
I don't know James Fink. That's someone else's attorney. He's not my attorney.
What if I have you on voice recording stating stuff that he told you?
James Fink is not my attorney.
Then why do you CC him in all our emails?
Because he's related to business attorney for Gloria Van, and she gave me information about Maple.
Why did you say you didn't know James Fink?
James Fink I know him as attorney for Gloria Vanderbilt. He's not my attorney.
Oh my.
What if I told you that I have a screenshot of you during Zoom asking who he is?
He's an attorney, but he's not my attorney. I never hired James Fink.
Why do you associate?
Next question.
Okay, my last question is it true that you told me if I keep ignoring you that I might end up like your prior attendant?
Prior attendant? What are you talking about? Prior?
Gabrielle Anderson, who is dead.
She died in my house, and I am concerned about people dying in my house. She did die in my house.
Whoa.
She had a heart attack.
I'm asking, is it true that you told me that I could end up like her if I don't reply to you.
No, not, that's completely.
Do you have that in writing?
Yes.
Pardon? Was
She
that a
said it in a
text?
text message. I have
She-
I have printed out.
Do you have a copy of that text message?
I have the copies of the text messages, yes, but I don't have them in the room with me right now.
And your understanding of that text message is, she said, if you don't respond to me, you could wind up like a tenant that is now deceased.
Yeah, she told me she's threatened me on multiple occasions.
That's ridiculous. Come on, don't sink to that level. I've never threatened you. Oh,
Miss Anderson, stop. Go ahead, next question.
And that's it. That's all the questions that I have.
Judge has a couple questions, maybe. Do you have a civil suit?
I also want to say that I do have pictures of the property
Hang on a second.
Okay.
Wow. We all have questions.
Paragraph 27 of your lease. Do you believe that if it's true that you contacted her neighbors, that there was the blocking of the driveway, that there was, if true, an implicit threat regarding Ms. Lyman's death, and that you're constantly going to the premises has interfered with her peaceful and use of the premises which you coveted it in that lease to provide under paragraph 27?
I haven't been to the house probably once. I think I may be driven by, not very often. I mean, I've probably driven by once, but I have not been to the house in a long time, ever since the incident with the police coming to the house. And I was just concerned about who was living
Read
there.
paragraph 27, particularly the second sentence.
Okay. Whoa. I'm giving her peaceful enjoyment. I'm not over there.
You don't think in any way you've interfered with her peaceful enjoyment of the premises?
I've been concerned about the house, but I mean, if she would just communicate with me, then I wouldn't be so concerned about the house. She doesn't.
What do you think her legal obligation to talk to you is?
Well, she won't give me access.
What do you think her legal obligation to talk to you is?
Since she's living in my house, I think I have some right to have communication with who's living in my house, just so I can know the status of things. I think I have some rights. And she's the only one.
Didn't ask that. Does she have a right not to say anything to you?
So she has the right not to say anything to me, but how do I find out about the house if I don't find out about it first? Since I don't have access to the house.
You rented it out. It's her house for all intents and purposes. You have extremely limited access.
Do you think she has the right not to say anything to you?
I think she should at least communicate, or if she doesn't want to.
All right, Ms. Anderson, you keep going on with these long convoluted answers. Yes or no? Do you believe that Ms. Lyman, tenant or no tenant, has a right not to talk to you?
I don't believe so.
So you think she has to talk to you?
On a minimal basis, just with regard to the home.
Under what legal premise do you believe that exists?
In the lease, it states that I have a right to number 18.
Judge takes a sip. Holy smokes.
Number 19, landlord's right of entry. Landlord or landlord's agent may enter the premises at reasonable times during the term of the agreement, and any renewal thereafter, 24 hours notice to the tenant. For the purpose of inspecting premises and all buildings and improvements thereon, to protect and make various alterations to show prospective renters, purchasers.
I read it. You don't have to read it. You can scan it and tell me where in that provision it makes Miss Lyman talk to you.
How do I, okay, Judge, I understand she doesn't have to.
Tell me in that provision, is there anything about that she has to talk to?
Well, it says landlord must notify tenant. How do I notify her she doesn't have to? Like if I want to look at the property 24 hour notice, how do I make that happen without having?
Is there anything in that provision that requires Miss Lyman to talk to you?
I guess not. I just don't know how to.
Is there anything in that lease that requires her to talk to you?
No.
Then why is it throughout this entire proceeding, and based upon the testimony of Ms. Lyman as well as what were the premise of some of her questions, are you forcing her or attempting to force her to talk to you?
Okay, she doesn't have to talk to me, sir. Maybe that's what we have here.
Then why are you trying to force her to do so?
Okay, I won't force her to.
I didn't ask that.
Okay.
Why were you forcing her to do so?
I'm just a communicative person, and I always think that things can be resolved by talking. So me wanting to talk to her is just part of my normal way of trying to resolve conflict.
Has she told you on repeated occasions she doesn't want to talk to you?
Yeah, she doesn't like it.
Didn't ask that. Has she told you on repeated occasions that she doesn't want to talk to you?
Well, she told me here she doesn't. She doesn't say explicitly, I don't want to talk to you, but she just says she doesn't like it.
Why do you then, when she expresses that, do you continue to try to force her to talk to you?
Okay, I'm sorry. I don't ask her to talk. Try to communicate.
Yes, Ms. Lyman.
I just want to state that I never told her that I didn't like her. That never came out my mouth.
Dr. Bullbutter, 23 months, OG. Thank you very much. Sounds like somebody's been deprived of their peaceful enjoyment of a property.
You never met my mom.
But they don't want to talk to you. You can't force them to do it.
I understand. I agree. I'm sorry, sir. It's just, I'll leave it. Sorry.
Why would you indicate to the neighbors that there's crack use at the house?
When I went in the house, I thought I saw like a crack pipe on the island. That's what I observed when I wrote my notes when I lived in the house. I put my.
When was this?
I sent it to the court. It's been a while. I wrote it. I basically documented what I observed inside the house.
Okay, let's say you document it. Why do you feel a compulsion to send that to the neighbor?
No, I sent the neighbors the information to know about living there because there was concern that this uncle was living there, and when I did a background check, it looked like he may have a criminal history, and I thought I was just I was trying to help you.
Tell me each and every fact that leads you to the conclusion that that person was living there.
the neighbors told me, especially when the police showed up, that there was an uncle. And when the uncle and the kids were moving in, they told the neighbor that they were the uncle and the kids moving in. And
How did you know his name?
because I looked it up, I did a Google search, and I did a.
How do you know that the name that you looked up and this person that you purport was supposedly moving in was the same person?
Based on the physical description of who the neighbors indicated was the uncle, and I looked up her, I kind of got her family tree nailed out from her grandma to her mom. You know,
What?
I figured out.
Why would you do that?
Because I wanted to find out who lived in my house. I didn't do any background checks.
Why would you do that? Have you ever, with another tenant, mapped out their family tree?
I was trying to find out who this uncle was because I was concerned with the neighbors. A bunch of little kids running around in the neighborhood there.
Wow. I mapped out her family tree. I figured out who her grandma was based on description. I figured out who the uncle was. I Googled the name, found he was on the registry.
You understand that if you're renting property, that the tenant doesn't become your indentured servant and or slave.
Yes, sir.
That's funny.
And that you can't force them to do certain things that they've not contracted to do. You understand that, don't you?
Yes, sir. What kind of contraction look like? Contracted thing?
You understand that because they're a tenant, you don't get the right to disparage their reputation with the neighbors? Do you understand that?
It wasn't Armand that I was concerned about. I understand though, I mean, maybe I understand that I shouldn't be concerned, but I was concerned because I just didn't know.
I didn't say that. You could be as concerned as you want.
Nervous.
Do you understand that you're not permitted to disparage her reputation that way?
That she could have legal recourse?
Do you understand that if you see or purport to see something that would be drug use like crack cocaine use, that you don't have the right to then become, I guess, the judge of what that is, what you think it is, and draw a conclusion and then
it's probably a vape pen.
Besmirch her reputation by sending that to the neighbors? You understand that you don't have a right to do that?
Jax.
Don't okay me.
Jax,
answer my question. Do you understand? Then why did you do it?
I was just concerned. I didn't know what to do. I was concerned about a bunch of little kids running around the neighborhood, and I didn't know who was in my house.
Or these little kids smoking crack? I mean, why were you tying that to the kids?
I thought it might not have been crack. I don't know.
Then why would you tell the neighbors it is? If you're not sure yourself, why would you tell them that?
I was telling them about the month. I was not telling
You didn't say anything about a crack?
I don't remember who I told about.
Did you?
I don't remember who I told about. I know.
Well, you better remember right about now, Miss Anderson. You have a very convenient memory. Did you tell any of the neighbors or intimate to any of the neighbors that there was crack being smoked in that house?
I saw crack.
Not an answer to my question. Listen closely. Did you tell any of the neighbors or intimate to any of those neighbors that they were smoking crack in that house?
I did, yes. When I did a Google search when I got it.
I didn't, there's no question. Quit talking.
Wow. This is just getting worse and worse. I did a Google search.
What months are you claiming are owed?
Just this month is owed. Okay.
If this woman's not careful, she could lose that $570,000 house to this tenant in a lawsuit for libel or slander or defamation or something of the nature. Wow.
What months are you claiming are owed?
July, August, September, plus the water bill that I already paid, $143.93. I called Pittsfield Township before.
I didn't ask you that.
And then
What months? Listen to my question. What months are you claiming she hasn't paid?
July and August are in escrow, and we're waiting on September. So September is the only one that's not in escrow.
So, as she indicated at the very, if she puts that in, she's paid in full.
Not utilities and not court costs.
She's paid in full for rent.
Yeah, but she still has the late fees that you already authorized on July 11th. You authorized the 150 late fee on July 11th.
She doesn't get it. She doesn't get it.
Water bill. Where's there a copy of the water bill?
Can I get it, sir?
Yes.
Thank you, sir.
And leave that lease on the stand.
Do you want me to come back up to the
Yes.
Okay.
That's the judge's lease that you've been writing on this whole time. He just asked you to read a paragraph. Oh, my goodness. She's basically paid up. She's a month behind, and it's just, oh, my goodness. I'm not sure if it's right or wrong. I pay all the bills for my rental unit. Internet's included, electricity's included, water's included, sewer's included, garbage is included. It's all paid for by me. And guess what? If we use a ton of water that month, I still pay it. If they use a ton of water, I pay that as well.
Ms. Lyman needs to see anything that's being presented to me.
Escrow is basically a third party holding the money. It's basically held in trust. It's not spent on anything. It's not given to anyone. It's held pending a decision or pending a transaction. And in this case, the court is holding on to it so they can make a ruling to decide who gets the money. Does it go to the landlord, or is there a reason that some of this should be refunded back to the renter? No,
Mr. Lyman, you indicated that you have been in contact with Pittsfield Township regarding the water bill.
Yes.
And have you arranged payment of that water bill?
Yes, I have already.
Yes, Ms. Anderson.
I just spoke with Pittsfield Township supervisor. He indicated that they had not worked out a plan on the water bill just an hour ago. I spoke with
Do you know who you spoke with?
No, I don't. They just told me that we could start a payment plan up.
Pardon?
They told me that I can start a payment plan up starting next next month.
Okay, who told you that?
Someone from the water department.
How much is the current bill?
She owes $1,327.94, and then I have already paid the prior water bill that she owed me for her part of it, which township water already confirmed
140.
was $143.93.
So you,
I paid that already.
have you paid the water bill?
Have I paid? No.
No, not you. Miss Anderson, you haven't paid this water bill?
I paid the water bill for me. It was already.
Give me the copy of the lease that I gave you.
Thank you, sir. Appreciate it.
He's going to notice that she drew all over it.
So the only thing, Miss Anderson, that you paid on this water bill is the $143.93.
Yes, sir. And sir, I can pay the rest of it today.
Ma'am,
Okay, I'm sorry.
I didn't ask you that.
Okay, judge doing a little light reading. $1,000 in back water payments. What did I miss? I missed the joke. Hang on.
Just want to be clear. You did not.
It's closer to our monthly charge.
You haven't set up a payment plan.
Yes, I haven't physically set up making any payments.
Pardon?
I haven't made any payments, no. I was just told that I could do a payment plan next month, starting next month.
October.
Yes.
And is there a monthly amount on that?
They didn't say yet.
Pardon?
They didn't tell me yet. Still trying to work everything out.
Just for FYI, we're under $1,500 a month for rent for our unit. It's all booked up for like 6 months, but usually gets booked up pretty fast. That includes off-street parking. We don't go through Airbnb. We go through a different service that targets traveling nurses. So we have nurses that come through on contract that need a place to live for 3 to 6 months, and that's who we rent to exclusively. I just did another contract yesterday. I did another contract for our unit. I'm like, clearly, I must be missing stuff. I don't have half the crap that this lady has in her contract. Did RA say his water bill is close to $1,000 a month? We have combined bills, so we have sewer, water, and electric in one bill from the city. And the most that's been, I think, was $3,200 in a month. When we had a water leak underground and didn't know about it and used, 80,000 gallons of water that month. That was a lot. Normally it's much, much lower. Usually it's well under 1,000.
Anderson, how many times have you sent Ms. Lyman a notice to quit?
I believe she's one time.
You have never sent her a notice to quit for the collection of rent.
The 30 days that I sent was because of the fraud, and it included but no rent, in that it was for fraud and non-payment of rent. At the time, she was late on paying
for fraud
rent, so.
I had a meter when I was over
How
in
many
England.
times have you sent her the rent or a notice to quit for non-payment of rent?
I think I did a 7-day notice.
Yes.
No, I didn't 7-day notice. I did 30 days.
Have you ever sent Ms. Lyman a 7-day notice?
No. 30.
How did you calculate the late fee?
Based on Google AI, 5% is the industry standard, so $150.
Did you just say ChatGPT?
Considered within the realm.
In Michigan?
It says, yes, 5% is the industry standard of the rent amount. We put it at 165, so I think 150 is fair. And that's
What do you think the purpose of the late fee is?
to try to encourage timely payments, and also
It can't be liquidated damages.
Well,
It has to somehow or another be related to your efforts to
well,
collect
like I
rent.
have to drive all the way to Detroit and come here, and that is gas and time. Gas isn't cheap. My time, spending days here. Starting to think I should work here.
I should work here? No, please don't. Please don't.
I just wanted to pay rent. I mean, I honestly.
I don't think there was a question.
Okay, sir, thank you.
Please don't work there.
Let's go to the application. When she filled out the application prior to renting, did you check any parts of that application to verify any of the information?
Yes, there was a number that's no longer working. It was supposed to be her landlord, Desmond Jones, that,
Did you get a response from this Desmond Jones?
no, but I thought it was her parents, so she was living with her parents at 99 Arlington. I thought, okay, I didn't, she didn't tell me.
Did you get a response from Desmond Jones?
No.
What else did you attempt to verify?
Well, since she was living with her parents, I took it as she was being honest that she was living there with her parents. She was paying $500.
Let me try this again. Did you attempt to verify any of the information that is on this application?
Well, the application showed me her pay stubs, so I knew it was through a legitimate company, Rents Free, and they verify information like that. So I saw the Ford pay stub, so I assumed that's where she works. The only thing normally I would have also done is talk to the current landlord, but because it was her father, supposedly, or her parents, I thought, I guess I don't need to talk to them since that number didn't work, and so I just didn't pursue that, talking to the current landlord. I didn't know that it was the other people that were the landlord. The Vanderbilts were the landlord, and I didn't know anything about it. She would have definitely steered me away, she said.
So just so that I'm clear, if Miss Lyman would talk to you, let you just come into her premises willy-nilly as you requested, would we even be here?
No, I mean, I would.
Okay, that's what my problem is.
I just want to know that the property.
The reason that we're here, is it not, is because she won't talk to you.
I'm concerned about my property.
There has been nothing detrimental to that application to you, is there?
Well, sir.
Is there anything that has been detrimental to you?
I have lost sleep over this, sir.
Okay, fine. We all lose sleep. Is there anything referenced to tenancy that has been detrimental based upon your reliance on that application?
I'm worried about my property, sir. If she does damage to my property, it's going to be well beyond her $5,000 earnest money. It's going to be well beyond that. And I'm worried. How am I going to recoup? How am I going to recover? I just want to sleep at night and know that my property is safe. That's all I want. I like Miss Lyman. I just want to know.
So, ma'am, can you answer my question? What in that application have you relied upon to your detriment?
I thought she was living with her parents on 99 Arlington, so I felt, okay, I wanted to get on her own. She's 20, I'm 22, and I thought, oh, what a wonderful young lady. She's going to college, she could be a nurse, she works at Ford. I really thought.
Okay, I'll try the question again, and even if you want to ramble on. What did you rely upon to your detriment in that application in renting to Miss Lyman?
I relied on the fact that she wasn't being evicted at her current residence. If I had known that, I wouldn't have rented.
That wasn't in the.
It's like, you know.
And you did not do a search regarding Miss Lyman?
I thought this application is rent-free with a reputable company for background checks, and I didn't see any evictions. There was no evictions on the report. So I thought, okay.
So they didn't pick up on it because there was no eviction. She might have been in court, but there was no eviction. What did she put on there that is fraudulent in your mind?
Her current address.
Why would that not have been her current residence if she were in the process of an eviction?
Because she was living on Maplehurst, which was the current address.
And you relied upon that. Did you do any other searches, anything regarding Miss Lyman prior to renting to her? So you took what she said in the application, put it through to a company, and relied upon that. So in point of fact, you didn't necessarily rely upon what Ms. Lyman said. You relied upon what the company gave you back.
But, yeah, the company. And what she hand wrote, no, it wasn't just the company, sir. There's also stuff she hand wrote that so her current address was 99 Darling.
But you took the information that she gave you, gave it to a company They ran it. And that's what you relied upon to rent her.
There was two things. That was part of it. Yes, sir. Yes, sir. Ultimately, you're the judge and you're right. So I'm not arguing.
Well, I'm asking a question, ma'am.
It's not what's fair. Whatever you think is fair, I'm going with whatever.
Ma'am, I just asked a question. You didn't rely upon the application. In fact, you relied upon what this other company had reported back. Right?
Yeah, they said no evictions, and they said
Okay.
They only said two addresses. That was the 99 Arlington and then a PO box. They did not show the Maplehurst on their search.
And I'm going to try again. And that's what you relied upon to do the search.
Yes, sir.
I know. What does that company require that you give them to do their search?
I think they charged us like $39.
They charged me $50.
And what information is submitted to them?
Driver's license, maybe her pay stub, whatever she puts in the, types in. I've never done this.
This is the company that you use, and it then comes back and tells you this person is okay to rent.
I mean, they said her credit score is low, and she had student debt, and there's, it's not perfect, and I don't expect anyone to be perfect. But I didn't see any evictions. I didn't see any huge red flags. Yes, sir. Yes, sir. Yes, sir.
So that's what you relied upon to rent to her.
Yes, sir.
Not the application that's been flaunted around here. It was the report back from this company.
I don't want to make you angry, so whatever you want.
Ma'am, I am not angry, and don't try that game with me. If I get angry, you are certainly going to know.
All right. Gotcha.
You'll be the first one to know.
She typed in information to a company. They came back, gave you a report, such as a credit score and blah, blah, blah. Can you point to the provision in the lease that incorporates the application into that lease?
The judge already knows the answers to these questions.
There isn't one, is there?
That's just what I used to, decide on.
If the application is not incorporated into the lease, then how do you evict her for what you say is a fraudulent application?
At this point, I'm not asking. I'm just asking for my rent.
I'm not asking.
She said, "Oh, I don't."
You filed a termination case to evict her.
I'm so tired of this whole thing, sir. I just want to get the rent and to have somehow see my house. That's all. Somehow make sure my house is okay. So
I don't know how you're going to see the latter of that, because at this point, I'll be honest with you, I think you've been harassing her to the point that you've interfered with her quiet enjoyment to the premises. And she may be entitled to damages for that.
She got quiet.
I haven't made a final decision on that. But I'm just going to tell you, you can't go around, rant to somebody and say, and it's one, you can't then go around and just say they're a crackhead. You might look, you might say, oh, and think to yourself, gee, Miss Lyman looks like a crackhead. I'm just saying, just for the purposes of this example, I'm not saying that about you, Miss Lyman, but you might say, she's got sex offenders living with her. You might say all of that stuff. It becomes a whole different issue when you begin to disseminate it to other people. And maybe
it hasn't reached the statute of limitations.
Maybe you don't get this, but with regard to the alleged sex offender, I have no idea if he is or not. There's a whole registry regarding that. They're required to give their current address.
I was just concerned, sir. I'm sorry. There's a lot of children running around.
It doesn't matter whether you're concerned. I could be concerned about whoever out there. I don't just go around saying to people, well, they must be a rapist. Oh, somebody's going to lose. I'm going to tell you that right now. It keeps up at this rate. But I'm going to tell you what. Ms. Lyman, was there any other questions you had?
Somebody's going to lose.
No, that's really it. I did wanted to say that I do have physical photos that I can admit of the property.
Well,
we don't need them.
Let's do it this way. And correct me if I'm wrong. But Miss Anderson, otherwise I'm going to need the text messages. But you told or intimated to the neighbors that there was crack use at that house.
I just said I saw a crack pipe.
That's all you said?
That's all I said.
Do you have, is that what's said on the text message?
I believe, I'm not sure if she CC'd the court in it, but it had like multiple messages with her and other people and stuff like that as well.
Yeah, I didn't say there was a crackhead.
Saying that it was a rapist in the home, and then people were like, that it was a...
Ma'am, stop. Go ahead.
Yeah, there was a sex offender in the home, and then she had people like, what is wrong with her? Oh, you need to get her gone, just different stuff like that. She has sent emails with the photos of that, yes.
Well, at this point, I'm not going to need the copies. Anything else?
Nope, that is pretty much it. And just the written thing that about my deposit of the $750, that's it.
Anderson, anything else from you?
I did look up in public records for iChat for her uncle, and it did say that he.
Okay, did it give an address? Did it give an address? So how do you tell the people around there that he's living there?
That's what they said. No, I don't.
I just want to say the person that she keeps claiming that's my uncle, that's not my uncle. 2 different skin colors is what she's going by. But
yeah, what?
On.
Why do you keep interrupting?
Because she doesn't want to talk to someone. She wants to talk at them.
The person that she's saying is my uncle is not my uncle. She's going off of the police report, but it listed 2 different appearances, and that's all I had to say. She just searched my name up and just tied that to me. She said that in the email as well.
I want to understand that.
She said she searched my name up and it said
Your name.
Yes, my first and last name. And she said that Google or whatever she searched up in said that he was my uncle.
Is it your uncle?
No.
No.
So this person she's talking about is not related to you.
That's not my uncle, no.
He's related.
Is he related to you?
Yes.
What is he?
A cousin.
A cousin?
Yes.
Okay.
Has he ever been at the property? No. If that's what I'm about to say.
So, okay. Just so that I'm clear, the person is a cousin of yours.
Yes.
Correct?
Yes.
And that cousin of yours, the one that may have this conviction, has never been to the property.
Correct.
Boom. All right.
So, Miss Anderson, you found somebody who was related to her. Do you have any personal knowledge that that person had been at the property?
Showed the pictures of the neighbor from Facebook.
Oh my God.
Because he was saying that the uncle lived there. He said he spoke with the mother, said the uncle lived there. And I said, does this kind of look like him? And he said, yeah, it kind of does. And then I started doing my searches. So this is all based on me doing my searches. And
My due diligence on ChatGPT and Google.
I didn't know who was living in my house. I was told that our money doesn't live there and that you're unwilling to so what am I supposed to say? I'm not there. Watch. This is what they tell me. Oh, about the
Here's not a question.
ChatGPT wrote an entire short story about the family, and that's what I based my letter on, Judge, because Google told me. ChatGPT, Google, Grok, all of it.
You can have a seat. You may step down.
This landlord now wishes this were just over. She's not enjoying the experience anymore, but she was the one who rushed to court to begin these proceedings. And when it didn't just become a quick settlement of a cash check in my, in my pocket. She's like, wait, I just want to be done. Well, that's not how it works.
Here's what I'm going to say. You filed this complaint for unspecified violation.
What'd you say, sir? I didn't hear that.
You filed this complaint for unspecified violations /fraud / misrepresentation of person in lease
/
which I believe those are two different things because you said you were dealing with somebody else and not Miss Lyman.
Yes, in the beginning, I was dealing with that lady in the back. Introduced herself as Joanne. That's who I was dealing with. She's her mother.
And persons in home and non-payment of rent.
Yes.
Those are the 5 bases. I'm going to tell you, and I'll just say this, and I'll let you guys give whatever statement you want to regard. Violations of the lease are tenuous at best. Fraud and misrepresentation of the person in the lease, which is this other person. Ms. Lyman has been here when the court required her to be here. It's Ms. Lyman. The fraud, stop. the fraud, there would have to be some type of reliance on something, but that's not what you relied upon to rent. So that's tenuous at best. Other than somebody's speculation, which is actually hearsay based upon hearsay, because supposedly they're the persons that are telling you X, Y, and Z. I have nothing to say that there are other people in this home other than your statement. And it looks to me like the rent's paid. What I do, however, see, and I haven't come to a final decision on any of this, I'm just telling you where I'm at, folks, is that there's been an interference with her quiet and useful enjoyment of the premises, and continues to be. And that there are potential damages for defamation, which relate to that quiet and peaceful enjoyment of the premises. So here's what I'm going to do. If you say you want to resolve it, then you need to resolve it. But I don't think, quite frankly, Ms. Anderson, you're in a position to get everything that you want.
Okay, sir. Whatever.
So you just have to talk. I'm going to give you two a chance to go out and see if you can resolve it. If not, I'm going to come back in and I'm going to resolve it. And I'm going to tell you that somebody is going to be very, very unhappy. And I'm not saying anybody has to do anything. But I think if one looks at it, you can see where your strengths and weaknesses are. Now, if you want me to make the ruling, I'll make the ruling. I don't have a problem doing it.
Everyone's like, let's go with unhappy, please.
I can tell you with reference to the claim of the monthly visitation, not going to happen. $750 is a curious question, but may have to be litigated another day, because as I recall from the previous proceedings, you had agreed that it would be
refundable if the condition met.
Refundable. But now today you seem to be saying that it's not, or that you're placing on it impossible conditions.
It's refundable.
That would require.
You keep talking, ma'am.
Ms. Lyman, you politely raised your hand. What would you like to tell me?
I was just saying I wouldn't want to break off and talk to her. That's all I'm saying.
Well, I'm going to see if you two can talk to each other. And all you have to do is agree upon a number. I don't really care how you got there. If you don't agree, you don't agree. I come back, I'll make the call. I don't have a problem.
Miss Lyman.
Okay? Court's going to stand in recess. You got 20 minutes. All right.
You got 20 minutes. Guess what? We're not going to wait for 20 minutes. Let's see.
No.
Okay, here we go. All right. Does it look like they reached an agreement? Do we think that in that 20 minutes they patched up all their injuries, repaired fences, hugged it out and sang Kumbaya?
Yeah, just the court for Connor Washington State basically direct session.
You may be seated.
Judge Simpson, like Judge Judy and many other great judges before him, about to lay down the law in this civil suit where a landlord takes a tenant to court for some simple things that really don't affect her, don't matter to her, and honestly, she shouldn't have any idea about. It's not her business. But after talking over the judge about 1 billion times, judge gives them one last time to reconcile, says 20 minutes to talk. Come to an agreement. Basically, the situation is this. You want to see inside your house? You want her to respond? Those aren't going to happen. You want your rent? It's pretty much paid up, or it will be in the next day or two. That may happen. But it's all the little things you did between now and here that could change this whole sentence, this whole verdict, and flip it in the favor of the tenant. So we're going to listen to Judge Cedric Simpson as he lays down the law here.
We're back on the record of the case of Anderson versus Lyman. Did you folks come to any agreement or no?
No.
No. Okay, very good. That's fair enough.
Can I tell you what I had suggested?
No.
Oh,
And I say it that way because the reason is that I didn't want to know what that process is because I've got to make a decision on it, so I don't want to know that. If there was an opportunity for you guys to address it, then you could have. And Ms. Lyman has indicated you didn't come to an agreement. Anything you want to say in regard to closing arguments, Ms.? Yes.
yeah, I'm willing to waive.
I don't. Go ahead.
Huh? Sir?
Go ahead. This is closing argument. Go ahead.
I told Ms. Lyman that I was willing to waive the late fees, to waive the court cost, give her the $300 for refund for her security deposit. So I would only be asking for $3,000 for September rent and then $143.93 for May water.
That's not very
I think
generous.
that's fair. And
Nope.
I also told her I'd be willing to write a statement about the security deposit being refundable if it's in room swept condition. So I thought that was fair. So all I would be asking for is $3,143.93 for September rent and May water. And then $3,143.93, and that gives her the $300 credit you wanted to give her for the security deposit for September rent. That's waiving all late fees and waiving court costs. And so I'm just asking for rent and utilities. And then I would be willing to sign something giving her security deposit back, as long as it's, clean, so I don't have to hire somebody.
Not dealing with the security deposit. All right.
That's
Lyman.
I feel that I should be compensated because she gave out my social security number and copies of my ID, which was attached to the email. A picture of my ID and my social was at the bottom.
Wow.
I feel that is defamation to my character, and it has the whole neighborhood in that email. Because I do not know them people at all, and my social is very, very sensitive information.
I did not give her social out.
I feel that.
Ma'am, Ms. Lyman, hold on a moment. She did not interrupt you. Go ahead, Ms. Lyman.
I feel that the late fees are excessive by some compensation of the rent, probably at least half if possible. If not, that's fine. Just think, just some type of recoupment.
Hold, please. Hold, please. Oh, no. Hello? Hello?
Hello?
Sorry, never mind.
Would be nice, just because I haven't been able to enjoy the home since moving in May. This rent, I feel like I owe $2,267 because I paid an extra $200 in June.
Hold on a second. You're arriving at that figure coupled with what you put into escrow?
Huh?
I'll let you finish. Go ahead.
I feel like I owe $2,267 for the month of September because back in June I paid an extra $200 and I moved in after May 1st. So $533 should have been prorated. I got that by dividing 3,300, then divided by the 31 days that's in the month of May, which came up to 106 and some decimal points. Then I times it by 5 and got $533. So that's how I feel that.
It just shows her work. That checks out.
Then from the security deposit of the 300, I added all that together and got $1,033. So I did 3,300 take away $1,033 to get $2,267 for the month of September. That's pretty much it. I just want to be able to enjoy the home without being bothered or anybody popping up or watching me.
All right. Thank you, Ms. Long. Ms. Anderson.
Yes, sir. I wanted to clarify. Our tenancy, our lease goes the 5th to the 1st. So what I explained to Armani is the reason why I didn't wait the first month. It started on the 5th and we go to the 5th. 5th to the 5th. She thinks that I should prorate it. I just started leasing it on the 5th. That's why I didn't prorate it. Not due.
Judge is making
so the 4th, not the first of the month. I was trying to explain that's why I didn't parade the first.
All right. Well, thank you both very much. What I'm going to do is I'm going to go through these calculations, try to figure this out. There will be no additional argument or witnesses on the case. I will render a decision and I'll set it for October 14th.
No.
Go ahead.
Oh, I was just trying to, do I turn these photos into you?
No, I don't need them. I'm good.
Okay.
So, October 14th, 2025, 9 a.m.
No!
Can I get the 2 zip drives that I didn't include as evidence since they have family photos on them?
Ma'am, once I am done with the case, as we have indicated to you, I will make a decision on that. I've told you that time and time and time again. But they were submitted to the court, and I had not yet heard the trial nor rendered the decision on the trial. I will then make a decision.
That have family photos of my little boy.
Ma'am, what did I just say? Thank you.
Okay, I've been led astray. I thought we had a decision. You guys asked for the verdict music. I thought you'd seen this. You knew where it was going. You were getting my live reaction. I didn't know it. TBC, to be continued. Judge asks to continue it because he needs to do some math. And I think what's going to happen is that the tenant's going to find that some of the money that she had paid to rent or paid into escrow for rent is going to be coming back to her because she did not get to use that property peacefully and enjoy her rental period, which was part of the contract. That was violated by the landlord. And the violations on her part, not so much. Not so much. So I wouldn't be surprised if a large chunk, if not all, of the money in escrow goes back to the tenant. And the landlord wishes she accepted whatever deal the tenant had offered. Josh knew and he didn't tell us. I had nothing to do with this, says Josh. Nothing to do with it. Well, we're all caught up. Guess what? It is 5 o'clock right now. It's 5 o'clock on a Wednesday. We made it through Hump Day. We are done. Yeah, it's a $570,000 home. I wasted the verdict music, but you heard it twice today. I know it was bad both times, but you heard it twice. So, for those that missed it, we did get a verdict in the Ohio versus James Ogletree trial. He was found guilty on all charges, even though his co-defendant was found not guilty. Two complete different juries, same set of facts, different result. Give us one more Hump Day roar before we end. I can only do one a day. We have rules, Laura. We have rules. Don't try to circumnavigate, that would be go around the world. Don't try to well, we don't want any of the words. There's a word that I'm thinking of, and it's not circumcise. That's the only one that will come to my head. Circumvent. There it is. Circumvent. Okay. Don't try to circumvent our rules here. We do see Frog tomorrow. That's it. Big Dill on the way out. We can do Big Dill. Okay, I got Big Dill ready. See anything else? You can't see. That's our rundown for the podcast. Podcast tomorrow night, 8 p.m. Thomas has done a ton of work already, and he's here in chat advertising that he's, in fact, ready for the podcast tomorrow, which, because it's the first podcast of the month, we'll be giving away some gifted memberships. So if you are trying to win one, being there promptly early in chat, having liked the stream is the best way to do it. As a matter of fact, it'll probably help if you like the stream right now as well, just to boost your standing in the algorithm for YouTube, who chooses who gets the prizes. So... let's see. I think can't find the original Frog in the old stream. It's there. We'll find it. I think it's there somewhere. But we're going to do the regular outro, and then I'm not going to sing Big Dill on this one. I'm not going to sing it. I'm just going to we'll do this one first, and then I'll play Big Dill as I'm just cleaning up and turning things off. How about that? You'll get to see the studio go dark. No, maybe it'll be just to the logo. I will work on Stubby Little Pencil. As a matter of fact, maybe I'll do that while I'm doing Big Dill.
I got a stubby little pencil.
Yeah, I'm working on it. I'm getting there. All right, you guys, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe. Do go live again tomorrow morning. We've got sentencing for Ogletree tomorrow. We have Frog tomorrow afternoon up in Thurston. We might have something from Judge Boyd tomorrow, a court case. We've got a lot of options, a lot of things we can go to. So it'll be a lot of fun. You guys have yourselves an absolutely fantastic day, fantastic evening. Podcast tomorrow. Plan on it now. You don't want to miss it. We'll have Stubby Little Pencil ready for tomorrow. So we'll be good to go. We will find the original Frog. We will find it. I think we've got a date. If we listen carefully on this one, he tells us the date it happens. So that might help. All right, I think that's all. I'm going to clap because I feel like a seal right now. I don't know why I did that, but it's been a good day. Yay. Right, you guys, have a good night. We'll see you. Bye-bye. Oh, that was the wrong one. Hang on. I didn't change the picture.
I saw a chicken fight.
I was kick back, taking it easy.
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection. From land t-shirts to murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells all rise. And pay respect to the one and only go to true crime. Imitators they try but they just can't achieve. And when they fail they be like, ow, I stepped on a beat. Take the stand and the jury chooses not to believe because there will never never be another creator like me. Big deal in one corner and the count in another. We've got the judge reading chat while we talk to the lawyers. All our clips go viral, they're too good not to share. Came in late, check the thumbnails, you'll find it all there. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real, just like a pickle jar, but I'm one big deal. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real, just like a pickle jar, but I'm one big deal.